Start.
Mention, Malad.
Lordship's leave, Milord.
All right,
With the
Mr.
Lordship's leave, may I mention, Milord, a very urgent PIL, which may be listed on Monday. Milord, it's a petition by students, teachers, and parents across the nation, challenging, Milord, a new policy of the Central Board of Secondary Education, by which, Milord, suddenly in the 9th standard, 2 more languages, Milord, have been made compulsory. I don't know how, Milord, a student in class 9 can take a new language as a compulsory language and, Milord, give an exam in the 10th. Milord, it is very, very different, Milord, what is happening. I mean, this will create a chaos. So my request is, if your Lordship may take it on Monday, Milord. It's a PIL filed, Milord, by students and parents.
Week is miscellaneous week. We will adjust the mail.
Now, Malad,
Your
may I-
Lordship may, Milord, put it any day, Milord, next week.
We will. Yes.
Your Lordships,
Malad, prayer
May I
is for
mention-
listing of a regular bail matter. Malad, it was verified on 24th of April 26.
It can't be.
30, Malad, it is please consider. 13th of May, it was listed along with some civil matters in an alternative bench. And thereafter, there is no date. So, Malad, may kindly consider in the next.
Lordship, may I-
Your Lordships, may I mention
Lord, may I mention?
Air India crash matter. It was supposed to be listed on the 25th of this month. We had moved a mentioning slip. The registrar assured us that it will remain on the 25th, but unfortunately it has not come in the list of the 25th.
Maybe not on 25th, then on 26th or 7th.
Your Lordship may kindly list it.
Just make sure the coming week it will.
Lord,
Your Lordships, may I mention this matter for the practice of 3-year mandatory practice rule, Your Lordships?
Lordship, may I mention? I have filed the
Lordship.
stay application in pending matter. My lord, I have filed the stay application in pending matter, my lord. So requesting for listing and any day in coming week, my lord.
What is the application? What is the urgency? We want to know.
My lord, because of High Court order, I am not, petitioner is not able to make the members since 2010, my lord.
Members
And
of-
more,
Members of what?
member of educational society, my lord. We are educational society, my lord.
Urgency
And
in that.
my lord, 1 minute.
Your Lordships, may I mention this?
My lord, more than
Your Lordships, I would like to mention.
May I seek Lordship's kind? May I seek Lordship's kind permission to mention a matter, my lord? Lords, I am mentioning on behalf of the Ayurvedic doctors in the state of Rajasthan. They are working for all the complete hours, but only on the salary of 50%. So Lordships, I have the judgment also
50% of what?
of the salary. Only 50% salary is given while we are working fully, and no leave is also given.
There is no great urgency.
With Lordship permission, may I mention a contempt petition which was listed before Lordship on 8th May. And then after it was showing for 29th May. Now, after the order came, it is showing 24th July. So Lordship, since the report is there.
Why you bother about contempt? We will see contempt. Contempt is made out or not.
My learned friend wants to.
Don't worry.
Your Lordships, I am just mentioning this 3 years mandatory practice rule, Your Lordship matter, if you remember, Your Lordships. This was tentatively listed for today, Your Lordships. And the urgency for mentioning it today orally is that, Your Lordships, the Bihar Judicial Services has notified their prelims of 3rd of July. And a lot of candidates are at a lot of uncertainty, because on the last date of occasion of Your Lordships passed the interim orders of extending the online application.
Same stage continuing.
Your Lordships, that's just if Your Lordships can pass just a simple order just for the extension of the interim order till the next date of order. Your Lordship.
Interim state to continue. On oral mentioning, the matter is taken on board. It is made clear that it is directed that the interim order passed on so date shall continue to operate till further order.
Well, with your Lordship's.
Lordships, in the next date of hearing, Your Lordships. Maybe.
Till further orders, it will be better.
Better than that. With your Lordship's permission, my lords, may I mention an urgent MA, my lords, which has been passed, my lords, which we filed, my lords, we're seeking listing in the next week. There is an observation made by the Bombay High Court. Now that is adversely impacting, my lords, my businesses, etc. I have started, my lords, several agreements which I have. They are all being cancelled on the basis of that observation. So I'm seeking that MA to be listed.
Our observations do.
No, my lords, Bombay High Courts, my lords, public healthcare system is being impacted. So I'm just seeking, my lords, if it could be listed in the next week.
Observations in a judicial order.
please, in a judicial order.
Are you challenging the order or?
My lords, that order has already been challenged. There is an observation by my lord Justice Sundaresh in the SLP which we had filed. This is an MA seeking a slight variation in that.
If the matter before Justice Sundaresh, application and it all.
Very well. That's all I'm asking. That's all.
The Lordship's permission, I'd like to,
Disposed of, matter by, or disposed of by Justice Sundaresh.
Justice Sundaresh. That's right.
Just before.
Very grateful. This side of the litigation.
the Lordship's prior permission, I'd like to mention a verified matter in which stay granted by the Honorable Bombay High Court expires on Monday and the matter's tentative list date is showing for Tuesday. So if we request for listing on Monday.
What is the matter?
The
What is
matter
urgency?
concerns the wrongful dismissal of part-time substaff in the Bank of Maharashtra. So the stay granted by the Honorable Bombay High Court expires on Monday. The matter is verified for Tuesday. We request for listing on Monday, Lord.
But then if still expiring on Monday, then have you requested the High Court to extend it? Or your claim has been dismissed?
Lordships, the SLP has been filed. It is verified. It is tentatively listed on Tuesday before this Honorable Court. We request it to be Monday. As per the computer verified, computer generated.
It will be listed on 26th.
We request for listing on Monday because the stay expires.
Nothing is going, buildings can't be taken away in one day. The stay, it is there till Monday, Tuesday morning your matter is coming for hearing.
Grateful.
चलिए भाई कुछ आज को काम भी करें.
Those two protected witnesses now have been examined, 271 and 272.
Both have been examined.
They have been examined.
I placed them on record. Both the witnesses have been examined. The gist is that neither of them implicate me in terms of the
How many
allegation.
otherwise, how many witnesses are left?
Now there are about 8 more protected witnesses who speak about the larger conspiracy.
And not me. And totally 300 and odd witnesses, they've said they've pruned it to 200. So the two witnesses against me don't implicate me, they're hearsay witnesses now effectively. The main allegation against me, sir, was that I took two persons to a house. That house owner comes and denies that now. Now what remains in terms of the charge order, what the prosecution case against me, nothing remains. There is a
Only the extraction from your
phone. Now the extracts of the phone are the extracts of the phone. There is no evidence that I shared it to anyone. The only evidence that they are placing is a disclosure statement I have given in custody to them. That is it. And then, of course, my disclosure statement. No recovery as a consequence of that.
It can be now released.
May say that any of the parity, that is, there are A 14, 15, 10 and 16 have been granted bail.
Same footing now.
5
same
persons
footing.
now.
And one, as against one bail, we have challenged before the High Court immaterial matters.
The Commissioner can be granted the appellant 6 is enlargement and review of bail. In case FIR crime number RC-29-2021 registered at police station National Investigating Agency Delhi under section 120 capital B, 121 capital A, 122 and 123 IPC, section 18 capital A, 18 capital B, 20 capital A, 29 of UAP Act 1967. Allegations are that so the case pertains to incubation of larger conspiracy in the custody of Delhi. Here it is alleged that physical and digital domains have been orchestrated by prescribed groups whose descriptions have been disclosed in the FIR and who are involved in radicalizing local youth for recruiting and training them in handling arms, ammunition, and explosives. The allegation against the appellant was that he was involved in providing refuse to the members of the international organizations. The appellant was arrested on 20th October 2021 and is in custody since then. The bail having been denied by the trial court as well as by the High Court while impugned order dated 22nd September 2023. The matter the appellant was approved this court. Next paragraph. Various orders were passed from time to time with a view to ensure that the vital stroke protected witnesses who were to depose against the appellant are able to report their statements without any fear and or influence, undue influence. But it is clearly stated by 11 editions also that such witnesses where the appellant had since been examined. There are, however, still some vital stroke protected witnesses to be examined, but their depositions revolve around the role attributed to the appellant's co-accused. Next paragraph. Some of the appellant's co-accused have since been enlarged on bail. The conclusion of trial will take some time. He is resident of
Kashmir,
Kashmir.
of Jammu Kashmir.
Jammu Kashmir. Have been released in bail. Taking into consideration the period already spent in the custody and the fact that conclusion of trial might take some little more time, and also keeping in view the parity claimed by the appellant, or without expressing any opinion on the nature, gravity of the allegations or the nature or the gravity of the offense. The appellant is directed to be enlarged on bail, subject to finishing bail bond to satisfaction of which in the NIA court, Delhi. NIA court, Delhi. The NIA court shall, in addition to the conditions that it may deem appropriate, will also ensure weekly presence of the appellant before the jurisdictional police station for the purpose of ensuring his physical presence so that no impediment in the ongoing trial is caused. No impediment is caused. The appellant shall also fully cooperate, the appellant and the counsel shall also fully cooperate with the ongoing trial, telling which it shall be constituted a case of misuse of concession of bail.
Most obliged. May I just make one small request? In terms of my co-accused bail orders, they are being allowed to be produced through VC. So I would just request if that physical aspect be left to the trial court.
You may request the trial court.
That's right. I'll just, the word physical may be, because my co-accused are appearing on VC and the trial court.
The appellant shall be requested to request the trial court for appearance through VC, and such appearance shall be considered as per law.
Most obliged.
Yes.
Listen, item 11, I'm being led by Mr. Jetmalan, who is appealing virtually.
Please, my lord. My lord, if your lordships kindly turn, my lord, this is an appeal, SLP, against an order granting bail to one of the principal accused in the matter, if not the principal accused.
Yes. Mr. Vice, can we take up this matter because we are in a partner matter last 3 days.
Well, I have no objection. My lordship may issue notice at least, my lord.
No, my lord.
Already there.
I am there.
No.
And I am objecting seriously because everybody has been granted bail. Investigations are complete. This is a fishing and roving inquiry for no rhyme or reason.
What are the ship fishing and but I'll point out the evidence.
On the one hand, you say that there shouldn't be a mini trial. On the other hand, you say that I will point out evidence.
I'll point it out, Mr. Hariharan.
No.
I'll point out your role and I'll point out the role of what's happening in this court.
Arbitration is complete, which it is, and there is no disciplinary proceeding which is not there. It may by order.
You may or may not file reply.
But notice has not been issued, my lord. We, in fact, wanted to be heard before notice is being issued because, my lord, if your lordship will see, the order is quite detailed. Everything has been taken care of. 6 months prior to that, there was no arrest carried out. There was not a single whisper of allegation against
Notice. Who is the AOR executing the matter?
the AOR. The AOR is Mr. Mayank Jain.
Accept notice. The counter affidavit can be filed within 4 weeks, 6 weeks. Post this matter.
Your lordship can hear it on some other day without notice. I am ready. There is no difficulty.
We are in a parted.
I will hear on every date, my lord.
Probably that the entire week we are in a parted matter, not only today.
I am not insisting that your lordship hears me today or tomorrow. Whenever it is convenient to my lord, your lordship may give a date.
No notice. Notice has to be issued. No business to be issued. Nothing other than leave notice. Are you having right to leave?
We filed within 4 weeks from a IPSO reply. We leave to you whether you require want to file or not. List in the first opening week. On 21st to 23rd July, any date.
Very well, my lord.
Obliged,
There is
obliged.
the other connected matter also in relation to the filing of the supplementary charge sheet, my lord. That is coming up on Monday. So then,
That we also might fix it.
then in that situation, if your lordship is not having the time, because that needs consideration, my lord.
Bail has been granted.
Bail has been granted.
No, we remember that those matters.
Yes, my lord.
Are you referring to those very cases?
Yes.
Those cases also.
My lord, these further investigation is such a process. Now, after pronouncements of this court, that permission needs to be sought from the court. It is being blatantly violated on every occasion. Though evergreening is continuing on and on. There is no end to this. So therefore, there are legal issues involved in that, and that is why your lordship had kept it for hearing.
Monday. No, if Monday you want to argue, from Monday we will be hearing the parted matter at 2 o'clock. So till lunch
Then your lordship will hear, because there is a bearing on this case also, this bail application, because one of
You're not on notice in that.
we are listing this in July.
Very well. Then I will make a mention, my lord, in the morning, and accordingly, your lordship can take both the matters together. I am so grateful.
Obliged.
Yeah, please, my lord. Lord, I had come earlier also, my lords had requested the High Court to decide my bail within 6 weeks. There, my lord, I had come earlier also, my lord, order is at page 253. My lords had directed the High Court request.
Students, you want
90 hearings have taken place.
we start directing High Courts to decide now.
My lord, I appreciate that, but 90 hearings have taken place in a bail application. My lord, the co-accused have all been great. All it requires is a hearing, my lords. Therefore, my lord, I'm requesting my lords may take it up here itself, my lord, treat it as a bail application here. My lord, there, my lord, about 40 accused bails are clubbed, my lord, the hearings are going nowhere. It's been 90 here, 90 hearings have happened, my lords. My lords have issued notice here, my lords.
Now we are dismissing, we can't entertain this kind of.
At least let there be some direction, my lords. 4 years I'm inside,
This is what exactly-
5 years almost.
The direction is very dangerous thing that Supreme Court will have.
I realize, my lord, but in this case, my lord, peculiar, kindly see, I've been inside for 5 years. But 2 years, my lord, my bail application is pending more than 2 years.
To this case before High Court, that's all.
Lord, at some observation, my lord, with that, for that I can at least persuade the High Court, my lord. Some observation somewhere. Some observation may be given, my lords. Lord, I'm requesting, my lord, because Lord, 90 hearings have taken place. I'm not able to persuade the High Court to take up my bail application.
Item 13.
One line somewhere
May I
here or some nudge, my lords.
I beg to appear. I beg to appear for the petitioner in serial number 13. Your lordship may please have para 1 of the impugned order, my lords, at page 1. This is, my lords, a complete fraud. I filed an OA before the NGT and relying upon a 22 judgment of NGT. And the petitioner in 25 moves a writ petition in the High Court challenging the.
Go to and become party to the High Court and move an application for vacation of
Well,
stay.
we are not even made a party before the High Court. They obtain an order behind our back. And
that is your major grievance, that you are not party and you are not been heard.
Please,
So please go and seek your impleadment in the High Court. We will make some observations.
Malas, the difficulty is that in Doon Valley for 20 years there were no stone crusher. State gives permission to a stone crusher. When the NGT is about to stop them, they file a writ which is not maintainable. Your lordship knows 22 is an appeal. This is a writ on merits. Malas, then your lordship may consider, Malas, staying this order because the crusher has started operating now because of this stay order. And we will take our remedies before the High Court, Malas.
No, please go there. The NGT had passed order at the instance of in a petition filed by the petitioner. In our country review, the appropriate recourse for the petitioner would be to seek his impleadment before the High Court in the pending petition and to further seek modifications to application of this order. Such application shall be decided, shall be taken up by the High Court. The High Court may, after impleading the applicant, after impleading the petitioner with party respondent, pass appropriate order after hearing both sides.
Grateful, Malas.
Deputy for mention the
I'm so deep here.
This matter pertains to the agreement between the bank builder and the buyer, my lord. There was a tripartite agreement, my lord. The petitioner booked a flat in 2014, my lords, and the loan was 95% of the amount was disbursed. Till today, my lord, the petitioner has not given the flat, my lord. The bank has proceeded in a OA and recovery proceeding is being initiated, my lord. So we request to tag this matter, my lord, with the main matter Himanshu Singh versus Union of India, my lord. That is coming on 28th, my lord.
The issue notice returnable to subvention matters के साथ है questions.
My lord, may I just request, my lord, that recovery will not be.
Unnecessarily. Meanwhile, execution proceedings हुआ, the petitioner or other similarly situated home buyers shall remain stay. However, the DRT or other prescribed authorities are directed to attach all the immovable and movable assets of respondent 4 builder, the managing director or another officers of the company and their family. कुछ ना कुछ harsh order करेंगे and their family. Their bank accounts be also increased.
Grateful, sir.
Lord, in item 15, the learned arbitrator has expressed his inability.
He is loka yukta, so he can't wait.
Yes, my lord. My lords may appoint any other arbitrator.
Any other arbitrator is fine.
Any idea about other retired judges?
My Lord, any arbitrator. We can possibly give a list of suggestive arbitrators. My Lord.
Suggestions if my lords want.
We can give some.
Retired judge's name in Bangalore.
My lords, these are the suggestions that we had. If my lords want to see suggestions.
My Lord, we can also hand over the list and.
Yes, if anybody, both, all of you, just it will refresh our memory and we'll appoint someone.
My Lord, Justice Gopal Goda is from Karnataka. Then there is Justice Ravindran is also there in Karnataka.
Because what is the value of the dispute? Justice Gopal Goda is a former Supreme Court judge.
My lord, that's the concern that I wanted to point out. As a petitioner, I'm a individual. So I'm an individual. The petitioner is an individual. So the claimant, may not be able to bear very.
My Lord, may appoint any retired High Court judge. My Lord, I'll leave it to my Lord, but let it be from my Lord, whatever is the direction coming.
The total value, my lord, is 11.3 crores plus interest. And
all right, we will change. We will just make an inquiry and pass it.
Much obliged.
Grateful.
Item number 16. I am a retired principal district judge for 26 years. I got super time pay scale, unblemished career for 26 years, blotless career, your lordships. And one human error. Judicial officers can commit error because there were two similar orders before me. In one, I allowed the condonation of delay. In the other, I did not allow.
So, how much delay, madam, you condone?
Lordships, the delay was about 22 years. But why I say so, it was on merit. Because I'm not on the legality, because High Court could have criticized the order and quashed the order. I'm here that the High Court condemned the judge as such. I'll be 65 years on 2nd of July. I'll retire.
Any notice for termination?
Yes, your lordships.
We are asking you, were you given a notice for termination?
Not at all. I was not given, not heard, no hearing, no show cause. Nothing. Lordships, I was on my dais.
Page 115.
I was sitting on my dais, holding my hearings. I was told in my ear to step down and thereafter removed unheard.
I understand, but at the same time, it is shocking our conscience in the manner in which he dealt with the two applications.
But there was High Court which could have quashed my order.
That's not the question. It's the same order.
Yes, Lord.
Two different applications asking for intervention.
Yes, Lord.
Both had 22 years delay.
Yes,
in
Lord.
one you allow, in another you reject.
Because, Lordships, that law came before me.
That means you are following
You show me the face, I will show you the rule.
Comes for a
I
judge
understand. That is a
sitting-
mistake. I'll not defend it. Your
for a
Lordship.
judge sitting in review, it shocks conscience.
That's right.
And that is why the honorable judge had reacted. However, what we see is civil consequences are followed without giving you a notice. That is why we
That
want
should not have been done. We are issuing notice that.
from the state.
Yeah, 5 years
Yes,
delay
Your
your. Of course, you are expert in condoning delay, but
It's not
don't
the
at least.
way in which a judicial officer.
I understand, Your Lordship. I will not defend it.
What happens, madam, is when you pass a wrong order, it is okay. But you pass a shocking order, it shakes the faith of people in judiciary.
That's right. I totally understand that, Lordship. It's my mistake. But Lordship, condemning me like that in a judicial order.
Madam, we have issued notice now. Please, next matter. Item
Lordship,
17.
let's maybe ask for expunging of these remarks against me.
With the notice, let the state come.
Yes, and Lordship, I'm retiring on 2nd of July.
You already
I'll be 65 years.
from your job.
Yes, Your Lordship.
Leaves from your job.
Lordship, may I say that I always lived in a dignified manner. May I retire in a dignified manner? That's the only thing.
Let the state come, madam.
Yes, Your Lordship. Grateful. Grateful.
Please, my lords. Item 17, I appear for the petitioner, my lords. My lords, this is a practical difficulty really that we are facing, my lords, which we want to bring to your lordships.
Yes. Difficulty?
My lords, it's a practical difficulty really, but it may, if your lordships read down the statute, that can be resolved. If your lordships kindly have a look at section 63(4).
Down in the statute. You
I
are
beg your-
reading something into the statute which the statute does not say.
My lords, may I just indicate, I see what falls from your lordships.
Sir, the expert under the Saksha Adhiniyam
Yes,
is an expert understood under section 45 of the Evidence Act.
yes, your lordships are right.
Knowledge and expertise, and
Yes.
not necessarily the government approved expert under section 79A.
Lords, this is with greatest respect,
Then
this is.
your difficulty is over. And
No,
these
well, very well, your lordships may only clarify this. I'll tell your lordships why I'm filing this petition.
See, these are safeguards for the genuineness and for the correctness of the electronic evidence.
Certainly. Certainly. My lords, therefore, I'm not.
Anything.
Anything, sir, even
Anything.
is very difficult now.
My lords, your lordships are entirely right. Therefore, I'm not really questioning the
In
requirement.
fact, we
May I
should
just-
encourage every university to give diploma courses of technocrats, blend them with the law course so that we can have certified experts in this field.
Quite right, my lords.
The need of
May I
the
just say
hour.
this? May I just say this? The difficulty that I have pointed out, sorry.
Mr. Turkar, once the
Yes.
responsibility comes, people immediately start learning it. The old habits die hard. That's the
No, your
old-
lordships.
under the old Evidence Act, we all are used to call the witness, all are asking examination chief, cross-examination. Now the very concept of leading evidence is changing.
Your lordships are entirely right. I just want to show one order, my lords, where the Honorable Madras High Court has also noticed that there is some discrepancy which is required to be addressed. My learned friend, Mr. Tang, is in court. May I request him to hand it over to your lordships?
Yeah,
Just
so
one
she
order, my lords.
And clarified what is the so-called discrepancy.
No, my lords, it has not been clarified. In fact, if your lordships will just have a look at that, if your lordships don't mind. This is, sorry, if it's been handed over.
In a given litigation where the issue arises inter party, we can interpret as you say.
Quite right.
Article 32, where you say it's manifestly arbitrary, we feel shy in.
No, I understand, my lords. Therefore, I may, although I may have taken that ground, I may not pitch it that high. I may not pitch it that high. I see what falls from your lordships. May I just show this order, my lords? This is at page number 1 of the compilation. And the relevant observations are at page number 4, paragraph 5. This is a learned single judge of the Madras High Court. May I read this, sir, with your lordship's permission? Paragraph 5. The matrimonial petition was filed in 2019. So page 4, paragraph 5, I'm reading. The matrimonial petition was filed in 2019. Therefore, the Evidence Act would apply and not the BSA, which came into force. However, the learned amicus, now this was something pointed out by the amicus who was appointed.
Now
The learned amicus requested the...
all obiter dicta.
Sorry, sir.
Once he has held it that this particular case, the old act will apply, Where was the necessity for writing all this?
Your lordships are right, but the Honorable High Court has noticed the difficulty which I want to bring to your lordships' notice. There is a compelling reason as to why a request was made. Section 63 of the BSA 2023 deals with admissibility of electronic evidence. Subsection 4 has been reproduced. Please see the next paragraph. The effect of the above provision is that filing of the certificate is mandatory along with electronic record. The certificate is to be signed by the person in charge of the computer system and an expert. The subsection itself refers to a schedule annexed to the Act, which is in two parts, A and B. A is to be filled by the party and B is to be filled by the expert. 39 of the Act deals with the opinion of experts. Please see subclause 2 of 39. When in a proceeding, the court has to form an opinion of any matter relating to any information transmitted or stored in any computer resource or any other electronic or digital form, the opinion of the examiner of electronic evidence referred to in 79A is a relevant fact, and the explanation says, for the purposes of this subsection, an examiner of electronic evidence shall be an expert. Then the Honorable High Court refers to 79A, my lords, and just under the quoted paragraph of 79A, the next two paragraphs are crucial. In fact, let me straight away go to paragraph 6. It is admitted by the central government that only a handful of entities have been notified till date as experts under 79A. It is surprising to note that no expert has been notified in the state of Tamil Nadu. It is beyond dispute that Tamil Nadu has good IT infrastructure, skilled manpower. Since the Adhiniyam has already come into force, very soon there will be a need for certificates under 63(4) for securing admission of electronic records. If experts are not available, that would result in denial of right of access to justice, which is a fundamental right. And thereafter, the Honorable High Court directed the central government to nominate such experts, my lords. Now, if this is how the courts are interpreting section 63(4), my lords, that is where the difficulty arises. So therefore, as your lordships, my Lord Justice Bakshi pointed out, that is precisely what I'm submitting before your lordships, that this insistence must not be made, my lords. That is the only clarification that I'm seeking from your lordships.
What with the provision?
I beg your pardon, sir.
Interpretation of the issue, right? This judgment does not address itself to the definition of expert in the Evidence Act. Presumably, what we can presume is because they feel, or the judge felt, that in the field of information technology, Section 39 being a special provision, it will prevail over the general provision of the Act.
Right. Now,
that is perhaps although not so clearly articulated, that may be the foundation of the judge's reasoning.
Now, may I just point out what the judge noticed? I'm sorry, I should have read it just above paragraph 6, after the quotation of 79A. If your lordship just see that paragraph on page number 5, it says, in light of the above three provisions, namely 63, 39 of the Adhiniyam and 79A of the IT Act, one can conclude that a person desirous of relying on any electronic record as a document in evidence must submit a certificate at the time of filing the electronic record. The certificate must be in A and B. B must be filled up by the expert notified under 79A of the IT Act. This is the difficulty that is being faced.
This is the line where we join issue with the judge. That last line in paragraph.
With greatest respect, that is also the only line that I am really affected by. Of course, not in this particular case, but across.
If you see section 39B,
yes,
39(2),
yes,
you see the form. The form does not prescribe only an expert notified by the government under 79 capital A.
Well, lords, there, if your lordship see the explanation thereafter, that is where the reference to 79A comes in.
That is only for 39(2).
Your lordships are right. The difficulty is that courts.
39(2) will exclude a relevant fact, because if you see relevant fact not only includes section 39, it includes section 40 to 45.
Your lordships are right. Your lordships are right.
That is expert, like handwriting. Just consider this, sir.
Yes.
Handwriting, how do you prove it? Through an handwriting expert?
Yes, my lords.
Also by a person who has knowledge of the handwriting of that individual.
Your lordships are right. My Lords, may I only say this? Sorry. This is the only clarification that we really require from your Lordships. And to that extent, 63(4) may be explained by your Lordships. Otherwise, this issue is going to continue to arise day in and day out before courts across the country, my Lords. Therefore, we have approached your Lordships. Ordinarily,
what 39B does through the explanation is, if a certificate is produced in the name of an expert, no question can be put with regard to his competence to depose.
yes.
But if you bring in an expert who does not have a certificate, you must lead evidence.
Yes.
With regard to his competence, experience, and foundation.
My Lords,
He has written 10 papers on this.
Quite
he
right.
has this education, and he is more than an expert whom the government could have certified.
Quite right, my Lords.
That again becomes a relevant fact which the opposite party can controvert. That is the difference.
My Lords, my apprehension is only this, and this is something that members of my association are facing, is that if my Part B certificate is not by an expert notified under 79A, my apprehension is that it may not be accepted at the first instance.
There is no.
Sorry, my Lords, I couldn't hear your Lordships.
We'll dispose it.
Would your Lordships keep the question of law open? Because I don't want this to come in the way of a litigant who wants to argue this at a later stage in an appropriate case.
At a meeting.
I'm grateful, my Lords. Obliged.
I was declared originally successful in the prelims exam. Now there was a writ petition was filed. And the High Court found that there some answer keys were erroneous.
What do you do now?
So it directed re-evaluation. Now, I was provisionally allowed to appear in the mains exam. Now, in similar circumstances, your Lordship, this court, as well as other high courts have followed that, have held that when the candidates are not at fault, don't disturb them, those who were originally successful.
No, supposing you are already selected, appointed, understandable that you can't be, you should not be disturbed. Can't be that you should not be disturbed. But here is the case, you are only in the process of the competing.
Yes, my lords. In similar case in the selection process, may I just place on record a couple of judgments?
What happened to your main exam, which you were allowed?
Main examination, I said there was an interim order. I was allowed to provisionally say the results are not yet declared. So that's why I'm waiting, my lords. I'm just hoping that I selected, and then you have an interview stage. So this is just an intermediate stage, my lords, in the selection process.
Challenge the earlier order.
That's right, my lords. The earlier order does not specifically say that you exclude those who are out of the merit list. It does not say. So we thought, my lords,
no need of saying once the three question paper questions have been doubted. Recasting of a successful candidate will definitely result in elimination.
Would your lordship just have the order, at page 62? It does not specifically exclude us, and we thought the High Court.
How can it not specifically exclude you?
Yes.
When it says that you take away marks from question 120 and 158.
Yes.
You see the operation of the operative part of the order.
Page 62, my lords.
Yes. You see that?
Yes.
There they have specifically said that
while re-evaluating the responses of all
question 145 option C will be treated as the correct answer, and option D shall also be treated as correct answer for question 120 while reevaluating the response of all candidates.
Yes.
So this all candidates.
Because I do understand, I do appreciate.
Do you understand now?
We
Now what happens is you argue before the court, High Court, that no, we have a vested right because we were.
No, I'm not
That's
getting
a
into
wrong
that.
approach.
I'm not getting into that, Milods. But courts have said, Milods, in the similar cases where Milods people have come to the court after Milods the select list has been revealed. Now there also, Milods, the courts have told don't disturb him. It was not their fault. The fault was with the examining authority. Now they have already put in a lot of hard work. Time has gone by, so don't disturb them. You take them. This is only because this is not an appointment. This is
sort of an order.
Yes.
May be possible. May. We are just contemplating may. If you had challenged the original.
Your Lordship,
Don't challenge the original order.
May I just place on record as one judgment and then I leave it to your Lordship? Because your Lordships have done this in other cases, and similarly, other high courts have also done it. Delhi High Court has done it, Please allow me to place on record, Kindly have Rajesh Kumar, and please have. Please have Rajesh Kumar, kindly have paragraph 2. It gives the facts, and then I'll immediately come to paragraph 21. Paragraph 2, which gives the facts. Application of an erroneous model answer key.
Different on facts. There was an appointment already made. Appointments cannot be set aside. Appointments cannot be set aside, sir. Here you are only on a select list.
If your Lordships may kindly come to Delhi High Court judgment, it has actually said.
No, you cited Rajesh Kumar. We are responding to Rajesh Kumar.
Yes.
Rajesh Kumar is a case where appointments and thereby vested rights created.
If your Lordships may kindly come to page 85 of Gunjal Sinha Jain, We now come to the second condition, which stipulates that the number of candidates to be admitted to the main examination should not be more than 10 times the total number of vacancies. Let us take the coin.
He is not being correctly advised. At the best, you could file a review petition in the earlier petitions.
Yes, sir.
Maybe saying that we have already appeared and.
Today, my lords, your Lordships, I am before your Lordships, the highest court.
Therefore, thereafter, you could probably challenge that judgment and this prayer could be made. Once having accepted that judgment, how can you feel out?
I was not a party in that judgment.
Therefore, it's a good ground that you should have gone for it.
I was not a party in that judgment. I am today only saying that it's only on equity.
No right has vested in you. You have only appeared in the exam. That's all.
No, I was successful, in the earlier exam. I was successful. That the High Court records that, in the impugned judgment. In the earlier results, I was declared as a successful candidate. I secured more marks than the last cutoff. It is only because the revised cutoff list is now issued that I miss it by 2 marks. Please have page 8.
That is the point that we are aware of. That does not give a right to you. Merely on qualifying the exam.
I do.
The selected candidate doesn't have right, which you want to assert now.
May kindly have in this. If your Lordships may kindly see, Paragraph 81. We must harmonize the requirement of the second condition with the requirement of not disturbing the candidates who have been declared as qualified, as also the requirement of justice.
How many candidates were there?
Milods?
How many candidates like you were there who had earlier qualified and because of revision of result?
That I'm not very.
That's a very important factor. For that purpose, you can approach the High Court through a review petition.
May kindly see this,
If your lordships may say, by re-evaluating the OMI answer script of all relevant countries on this line summary. In this manner, all persons who could legitimately claim to be on the top 230 would be included. All those who were earlier declared as having qualified would also retain their declared status. Although the final number of qualified candidates may exceed the figure of 230, this is the only way, according to us, to harmonize the rules with the competing claims of the candidates in just and fair manner. And my lordships, this has been reaffirmed in another judgment of the Delhi High Court, my lords. And in fact, there is a judgment of this honorable court, my lords, which I have also placed on record. If your lordships may have page 91, this is slightly in a different circumstance.
The problem is that you are depending more on judgment. All these judgments are irrelevant. None of these judgments has any applicability more.
No, my lords, these are cases where my lords, the courts have considered, my lords, on principles of equity.
Do you want to go before High Court?
My lords, I will then. Just simply may give me liberty to challenge.
The petitioner has been excluded from amongst the qualified candidates in the preliminary examination as a consequence to the judgment dated 18 December 2025 passed by the High Court in a batch of petitions where the answer key was challenged. Where the answer key published on 31st October 2025 of the preliminary examination was challenged. The petitioner, though declared qualified in the earlier preliminary examination, has now been disqualified upon revision of the result. Since the petition did not challenge the judgment dated 18 December 25, the High Court seems to be right while rejecting her claim, her subsequent petition, questioning her exclusion. Faced with this, non-consent for the petitioner seeks and permitted to withdraw this special petition with liberty to approach the High Court through a review petition with liberty to file a review petition for modification of the judgment dated 18th December 2025. So, the special petition is accordingly dismissed as withdrawn with liberty aforementioned.
I may be allowed to review, seek a review of this judgment also, this impugned
We
judgment.
have not expressed any opinion on merits.
I may be allowed to file a review petition of this impugned judgment also, because again, I'll have to seek a review. Otherwise,
First, if you succeed in the earlier one, then only you will succeed.
I'll file both of them together, my lord. So,
If you feel that if you want to spoil your case, you do that also. We can't do anything.
I'm led by the Solicitor General.
So, Mr. Raju can start. No? Lord, we may have to file two petitions as additional because in one SLP there are 3 orders challenged, and we'll have to add accused also, my lord, as respondent, other co-accused.
That's right. They are also not. We can take up after the.
Otherwise, the order is all 3 orders are bad on face of it. Lalji's judgment is not applied for unlawful assembly.
We must complete the filing and implement, then we'll see.
Very good.
One Solicitor General, stroke additional Solicitor General, so you can grant it in time as in connected special petition and implement of the persons or parties are required to be made. Post the matter on so and so day.
Grateful.
May it please wait. As the matter is fresh for regular bail, your lordships have been pleased to enlarge 19 out of the 22 accused on bail, my lords. Almost all of them.
The notice.
This was pointed out to the High Court, my lords. We pointed this out that your lordships have been pleased to, but the High Court holds that the others went.
First June. We have placed on
1st June, my lords.
For 1st June 2026.
Lordships, issue notice in the meantime, I'll complete it. Otherwise, 1st June, my lords, they'll notice, my lords, returnable 1st June, I'll serve them so that form.
For 1st June only.
Yes, my lords, oblige, my lords.
That can be disposed of in light of judgment passed by this Honorable Court on 11th of March 2026, my lord. So he is covered, my lord. And review petition was filed prior to the even Constitution Bench judgment in September 2025. My lord. Somehow it could not be listed.
At least now, who is the one is review petition?
My lord, it was filed prior to Constitution Bench judgment, my lord, against the three budget. It was filed. This review petition was. This is, my lord, judicial officer's matter, my lord, regarding 7 years of practice and 7 years of experience at bar, my lord. So review petition was filed in September 2025, my lord. It could not be listed along with the other matters, my lord. So my lord has passed an order on judgment on 11th of March. So it is squarely covered, my lord. So it can be disposed of. That's what I'm saying. It can be, this review petition can be disposed of in the light of.
The non-counsel for the review petitioner say submits and rightly so that this review petition will be disposed of in light of the 5 bench judgment.
Yes, my lord, by this court judgment, 11th March 2026.
29th October 2025. In Rajanish KV versus K-Deepa.
K-Deepa.
In terms of 11th March 26 order of our bench.
Yes, my lord.
Then you should say like this.
No, I'm so sorry, my lord. I could not convey it properly, my lord. Squarely covered by the judgment delivered by my lords, 3-judge bench, dated 11th March 2026.
So dated 11th. You are saying 11th, this is the order.
Yes.
11th March order, 11th 2026, passed in a batch of petitions, including petition civil number 759 of 2017 and 1278 of 2019. Okay. There was one more petition listed.
That is 45, my lord.
पता नहीं क्या वो करते थे कंफ्यूज इसको साथ को अलग अलग लगाने की तो serial number was only this one.
Only in respect upon 42.
All right, item 45.
Please.
Was selected in 2013. Thereafter, he cleared the mains. He was the only person, my lord, from the Delhi judiciary. There was an order, my lord, in 2018. And in the meanwhile, in 2020, he was regularly promoted.
No, you are the original writ petitioner.
Yes. What happened, my lord, is that in 2015, my lord, there was an interim order directing that he be interviewed. High Court did not do that. Then the matter went on, my lord, and then 2018 there was a direction from the Honorable Court stating that the selection be complete.
The problem is that I think these applications are separate. High Court wise should be taken up. All mixed up. Now, what is your claim? There is more.
I am there is more.
What is your claim?
My lord, my claim is this. I applied, my lord, in 2013. But thereafter, my lord, in a writ petition filed by me in 2014, there was an interim order that was passed by the Honorable Court asking me to be permitted to participate, my lord, in the direct recruitment of 2013. My lord, I qualified in preliminary because this question of 7 years was there. And then at page 4, sorry.
How to grant seniority from backdate when the 5-judge bench says prospective?
Not that, my lord. What happened is, Your Lordships categorized it into A, B, and C.
Hmm.
I have been put under C, but I should have been put under A. Because my Lord had the.
But that, then, Mr. Giri, that's a separate cause of action. For that, you approach the High Court by a writ petition.
No, my Lord, I had approached the High Court earlier. That was declined. And then I came here.
If according to you, the order dated 11th March 2026.
Yes.
Are you agreed by that order or you want?
I am seeking modification of that order, my Lord, insofar as I am concerned because of these reasons. One, I should have been categorized under A by the amicus, my Lord, pursuant to your Lordship's order for this reason. My selection was not completed only because the High Court, my Lord, failed to comply with an order that was passed by this Honorable Court at page 45.
We were very consciously clear. We didn't want the meanwhile Director Court appointed that they should be affected. Otherwise, it will lead to so much hard burning. They are not before us.
No, my Lord, let them put me at the bottom of the list, my Lord, insofar as 2015 selections are concerned. But please have a look at page 45.
To subsequent batches.
Not that, my Lord, earlier, 2015 direction. Please have a look at page 45, 46.
Appointed in 2020.
That is, my Lord, a regular promotion. Regular promotion. That has nothing to do with this.
But your problem is not our order. You please see, your problem is the 5 judge bench, which says it will apply now prospectively. Because of that, the earlier issues were not opened.
Not earlier issues, my Lord.
Somebody should have argued your matter at the before the 5 judge bench, saying that please don't apply this prospectivity principle in the cases which are pending.
Lord, I did apply. I did appear.
No,
I
but
did appear, my
then
Lord.
you see the judgment.
No, my Lord, the judgment, my Lord, actually.
So therefore, Mr. Giri, either you will have to seek review of the 5 judge bench.
No, my Lord, I really don't want a review.
Just see the 5 judge bench judgment.
The Lordship permits, I can read out the relevant para, Manus. Para 170 of the 5.
Do I remember correctly?
Yes, Manus. If Lordship permits, I can read it out, Manus. It says in any case, we clarify.
In any case, we clarify that we have held in this judgment will be applicable only from the date of the judgment, and in no case any selection process completed.
Now, been sitting a composition of 3, and particularly when there is no review before us, and in any case, it's a conscious decision by the 5 judge bench, because they did not want to open.
That remains intact, because I can't now say, my Lord, I can't plead before your Lordships that there should be any review of that.
Therefore, Mr. Giri, it is not because of by virtue of our order of 11th March. 11th March order is only a simple execution of the 5 judge bench order.
Correct, my Lord.
Judgment.
Correct, my Lord. Therefore, when that was done, what the amicus should have taken note of and brought to your Lordship's notice, and which, my Lord, I could not do that, is this. Though I was categorized under C because it falls under the category of selection process not completed, pursuant to a 2018 order passed by your Lordships, by the Supreme Court, there was a direction that my selection be completed and I be appointed, which was given to many others.
But then the point is that you were never appointed.
My Lord, 170 itself, your Lordship said 170. In any case, we clarify that what we have held in this judgment will be applicable only from the date of the judgment, and in no case any selection process completed or any appointment made prior to the judgment would be affected, except in cases where any interim orders were passed by the High Court.
If the appointment is made, then it is not to be affected.
Correct, my Lord.
But unfortunately, in your case, no appointment took place.
Appointment could not be made, my Lord, but there was an order. There was an order, my Lord, which they failed to comply with.
Order was, but the order which was not implemented. How today, when 5 judge bench has created an embargo, how can we give effect to that order? Unless an exception is carved out.
There's an exception carved out, my Lord, in the case of orders passed by this Honorable Court or by the High Court. I fall under that category.
No. In 5 judge bench, please show the exception.
My Lord, that's para 170. Para 170 is what your Lordships are referring to. In any case, we clarify that what we have. Sorry.
It's a contingent position, Mr. Giri. We understand that the High Court's dragging its feet, notwithstanding the Supreme Court's order that it can continue with the selection process, may have denied you the opportunity of appointment, but the appointment, in fact, of the selection was not complete.
That's correct, my lord. Selection only because if it
How
could, your
do
lordship,
we-
kindly
how
have a look
do
at
we
page 45.
Answer one question.
Yes, yes.
How do we know that you would have succeeded in the interview?
No, my lord, that's not what happened in this case. There was a direction that the selection.
We
be
are
completed.
again asking you, did
Yes.
you subject yourself to the interview?
They did not, my lord. There was a direction.
Answer is no.
No.
The reason you come before us, Mr. Giri, just construct your argument.
Sorry.
Answer is no.
Very good.
But you come before us because you say that how could I have appeared before the interview, because the High Court, in contravention of our order, did not hold an interview.
That's correct, my lord.
You are absolutely right there. But if the High Court had held the interview, is it an axiomatic position that you would have been appointed?
Maybe
you would have been selected? So there is
may not be possible.
a layer of contingency, even if the High Court had complied with our direction. And hence, we will not allow this application.
No, my lords, the direction at page 45 is not merely to complete it. It's not merely to complete it. Please have a look at that.
You see, if our order of 11th March 26 is in a way inconsistent with the 5 judge bench judgment, then probably this kind of application we can understand. That 5 judge bench had granted me some relief, which by misinterpreting that judgment, the amicus suggested something and we have deprived you. That is not the case.
What your lordships have directed, my lord, in the 11.3.26 order is to categorize, to accept the categorization made by the amicus. Category number A is where appointments were effected, but later on the basis of the first Dheeraj move, the 3 judges bench, they were reverted. What happened, my lord, in the case of category C is where the selection could not be completed. Selection could not be completed, my lord, in my case, and I believe that I'm the only person who comes under the Delhi subordinate judiciary. I'm the only person. And in my case, the selection was not completed in blatant, my lord, disobedience of the order passed by this honorable court, 2018. And thereafter, my lord, there was a direction in 2019.
Therefore, according to you, the Delhi High Court was in contempt. There were only two possibilities. Either the High Court was in contempt or the High Court was in fix how to give effect to the directions.
No, my lord, what could have been brought to your lordship's notice by the amicus that...
Let us not forget, Mr. Giri, unfortunately or whatever way, the law of the view taken by this court went against you at that time, at that stage.
Lord, please look at the irony insofar as this young man is concerned. He is Dheeraj Moore, the one person who took up the whole matter. And ultimately, my lord, it ended with your lordship's direction in the lordship's judgment in the Constitution bench, followed by the 11.3.26. And
our problem is that we are bound by 170 of 5 judge bench.
Yes, my lord, 170 carves out an exception regarding certain interim orders. In my case, it is not an interim order. It's a final order at page 46. Followed by another order, which is again passed, my lord, at page 59.
Yes.
Another order passed by this honorable court. There's an application, my lord, I'm sorry. There's an application filed by Dheeraj, starting at page 57, MA 1249 of 26. If your lordships kindly have a look at the order at page 45, the first instance. Starting at page 44. The petitioners, interveners, applicants, I fall under that. In these cases, have been permitted to participate in the selection for appointment to the high judicial services in the respective states while serving as civil judges. It is prayed that the selection process may be taken to its logical conclusion, making it subject to the result of the petition. In writ petition number so-and-so, a coordinate bench of this court passed the following order. The larger question arising from the issue whether the judicial officer who has already completed 7 years in bar being recruited for subordinate judicial services would be entitled for appointment as additional district judge against a bar vacancy is pending consideration. Thus, this matter would be tagged at the petition so far as the main matter is concerned. Now, turning to the interim relief in the present matter, we must take note of the fact that there is great positive judicial officers. Petition number 2 has qualified in the written examination interview. Then the last paragraph, my lord. In view of the aforesaid position, we are of the view that the High Court may proceed to appoint petitioner number 2. That's, my lord, in the other case, to the higher judicial services without his resigning from the subordinate judicial service and subject to the result of the Constitution Bench. Having heard the learned counsel appearing for the so and so, we are of the view that a similar approach
At the time 5 judges was being argued, or in 5 judges some clarification should have been sought, that here is a case where despite the interim direction issued by this court in your favor, the directions were not implemented, as a result of which you have not been able to qualify before the cutoff date, which has been now, which find place now in 170. And this has resulted you in denying the seniority part. But that will be only a modification or clarification in 5 judgments.
Lord, I am before my lord. Would your lordships consider whether this application could therefore be, or a similar application could be considered, my lord, by the Constitution Bench?
So we probably, I'm not sure how can we. Order was complied with. Direction is again, this issue is again very speculative. All contingent, whether you would have qualified or not, what would the, suppose they had awarded you 0 marks in interview, then what would have happened?
Let's see. Again at page 59, sorry. What is subjective?
Allowed only to participate in a selection process.
I was
It unfortunately never culminated into any selection.
There was another direction, my lord, at page 59. So far as the second class of persons is concerned, because I don't fall into the first class. The first class of persons were they who were yet to take the examination. Mine I had taken, my results were also announced, but they did not permit me to participate in the same. That is why, my lord, this direction to page 45 came. Again, my lord, there was a direction by your lordships. My lord, the chief, incidentally, was a party to that. And at page 59, it is stated, so far as the second class of persons is concerned, these are persons who have cleared the examination, but not appeared for interviews. This process may also be undergone by them, so that the results may be given to us in a sealed cover. Let there be a minimum of 1 week declaration of, sorry. Had they done it in 19/7/2019, at when, my lord, the original Dheeraj was pending?
We can appreciate that you say sheer bad luck that you fought for the others.
I've been batting for this for the past 6 years, 7 years. No, 10 years. And in the meanwhile, my lord, he got a regular promotion. He's the only person, my lord, who stood in.
After all, our problem is that we need to be fair to everyone.
Your lordship should.
Now, the moment as a result of misplaced sympathy, emotion, or anything out of way, then it will open Pandora's box on pan-India basis. Every state has this problem. What is your problem?
Permission of this honorable court, my lord, he has
Actually, categories.
Selection process, and thereafter I have
Nothing can be done now. You have been subsequently promoted. Your is Haryana cadre. What happened to that lady? Because only one officer was there who was selected and appointed also, but unfortunately High Court removed her. She might be entitled to. Yes. I'm not sure about.
My lords, there were 3 candidates in the state of Punjab and Haryana. One Mr. Mandeep Mittal, one Madam Karuna Sharma, and
no, but what happened? What is the order passed by this court now in your claim?
In wide order at 11th of March 2026, my lords, I was appearing in 3/80/2021. I was a petitioner. That was related to state of Rajasthan.
Forget about 21. The question is that now, after the 5 judge bench, what is your status and what is the status of all 3 candidates?
I have still not been called for interview, my lords.
I have not been called for the interview, my lord.
Still, I have not been called for interview, my lords, after 11th March 2023.
Where is the question of interview now? Is there any? After the The only thing is that now you have become eligible. But those who have been appointed, they are entitled to reinstatement probably. Because the order one, paragraph 170 says, the appointments if taken place, those are not to be effective.
Category A, Manoj, specifically
Exception was
for
carved,
those,
my lord.
category A specifically for those, Manoj, who had got the benefit, but pursuant to the subsequent judgment, Manoj, had been demoted. So Lordship were very conscious, Manoj, that
We wanted to avoid litigation, otherwise.
Manoj, that it would open Pandora's box,
Ordinary
which
we
Lordship
can
is saying.
still ignore, but we didn't want to have litigation otherwise.
Not indeed.
Acted before the five judge bench.
No, my lords.
Ah,
I was
that is
denied
the problem.
permission to appear in the interview. I was the second topper in the written examination, but I was denied permission to appear in the interview due to Dheeraj More case. I kept on fighting for this legal issues.
Now, the amicus report categorized it into four. C category, the amicus says, my lord, if your lordships kindly have a look at that.
No, you are unnecessarily after amicus. Amicus has done nothing. Amicus has simply given a way out that how to implement the judgment.
Actually, my lord, in the category C, there are only four. And in the meanwhile, my lord, I was promoted on a regular basis in 2020. What I'm seeing is, I participated in the selection which was initiated in 2013.
Mr. Giri, we follow you very well. We understand that on equitable principles, you feel really
right on. We have heard
treated, you're on the wrong side.
We have heard Sri Giri National Counsel for the applicant. We have also considered the claim of the other similarly placed persons. The five judge bench judgment dated 9th October 2025 in so-and-so case has categorically held as follows. Paragraph 170 and then direction 172.
Right to the
172, then 174. That's all. Next paragraph. On a plain reading of paragraph 170, there remains no doubt that the judgment has to be applied prospectively with effect from October 9, 2025. The bench, however, carved out an exception in favor of those where, inverted commas, any selection process completed, comma, or any appointment made prior to this judgment. Dash dash inverted commas closed. In other words, if a direct recruit or even a serving judicial officer who had been permitted to participate in the selection process, and had been selected or appointed, all such appointments, selections and appointments have been protected. Such selected officers are entitled to appointment, and if such appointed officers were relieved on the ground of eligibility, they are also entitled to seek reinstatement. However, in terms of para 170 reproduced above, it is clear that on the basis of contingent selection or perceived appointment, no effective relief of deemed seniority can be granted. No relief of deemed seniority can be granted. The review petitions are disposed of with this clarity.
Can we, now that if your lordships have taken a decision on merits, but otherwise, my lord, we could have gone back to the High Court for any
Determination of seniority.
for determination of seniority. These are two streams of recruitment, I understand. One is regular promotion, the other one which I'm asking for is a direct recruitment under 233B. Is there anything, any way that your lordships would proceed so that he can approach the High Court
In case of seniority.
insofar as seniority?
He should have probably, we don't know what happened. Because he got promotion meanwhile, that's why it seems that he also slept over. Otherwise, frankly speaking, Mr. Giri, he should have sought implementation of the orders passed by this court.
What happened, my lord? He did try for that. That's why, my lord, when the other order at page 53 came. But in the meanwhile, my lord, Dheeraj Moore was taken up by the three judges bench.
And overruled. So that's
That's what happened, my lord. There was nothing that he could do about it. And a serving judicial officer, he doesn't, my lord, he does not lightly, my lord, embark upon a case of taking up contempt against a High Court administration.
Shall we direct you, accordingly directed to review the individual cases and take an appropriate decision. Which orders are what we done. तो contingent appointment में कुछ नहीं कर सकते, लेकिन जहाँ पहले selection appointment हो गया, then they are in service. That is it to
Great.
Item 49. Same. अच्छा ये उसका था 24 का अब ये क्या हो रहा है
With the permission of this honorable court, my lord, I have participated in the selection process.
We have clarified कर दिया
Obliged.
Same model. Yes, item 43.
My lords, item 43 and 44. My lords, I will withdraw. My lords, I've already passed an order in a connected MA number 1499-1500 on 11th of May, my lords.
Same model.
Please, my lords, I pass a similar order.
Item 46. The petitioner has filed the instant petition seeking a direction to Allahabad High Court for expeditious disposal of his resolution number 13995/2023, which is pending before the High Court. And our concern will be no such arbitration. In our consideration, we do not find any ground to entertain the instant petition. The petitioner full stop which so advised from may approach the High Court with an application for early hearing and make out a ground for out of turn disposal of his case. The High Court will consider such sympathetic.
Lords, I appear for the petitioner's hearing, who, my lords, are candidates who contested in the Bar Council of AP elections.
So now you want a reverse thing.
My lords, I am only saying these 2 seats should be over and above the 25 seats which are statutorily mandated as per section 3(2).
No place to entertain the writ petition later.
My lords, in the meantime, my lords are issuing notice in the matter.
No, we are not entertaining. If you want to go to Justice Dhulia's committee, etc., you can go.
Yes, yes. My lords, I have already submitted a representation my lords may give a direction that the same shall be considered and whatever appropriate remedies.
If we will not issue any direction, you can, if you want, otherwise we are dismissing the writ petition.
Then my lords may hear me then on merit.
Go like, yes, argue please.
My lords, I am premising my argument on section 3, which says 25 members are to be elected through my lords vote, to single transferable vote. My lords have issued an order saying that the 30% and 10 out of that 10% shall be co-opted. But in paragraph 7 of that very particular order, my lords have used the words enhancement of seats. Thereafter, the Bar Council of India has issued a clarification that which was not in public domain. We only came through, my lords, in the when it was extracted in the election notification, saying that these two has to be from within the 25 seats which are earmarked for election. Then, my lords, we are saying that it is not permissible in view of the statutory scheme. Earlier, one attempt was made in 1976. An amendment was brought in for nomination of members. Thereafter, that was revoked in 1977, saying that, my lords, the principles of democracy, my lords, and the election has to be, my lords, respected with respect to the bar councils, because the autonomy, that was the object behind the act. Earlier, my lords, under section 4 of the 1926 Act, my lords, 2 judges can also be among the members of the bar councils, my lords. Thereafter, my lords, an All India Bar Committee has been formed, and they have given out, my lords, the objects of the Act, saying that it is autonomy, uniformity, and integrity of the profession, my lords. Here, my lords, once we wear the gown, my lords, there is no gender, there is no caste, my lords, there is no such differences. I am saying, my lords, just merely leave it to the, my lords, wisdom of the voters. These are educated voters. If they have faith in a particular person that he will better represent the community, and, my lords, they have casted their votes, they have exercised their votes. If not, my lords, for these co-opted members, they would have been within the 25. They stood at 20th and 21st. My lords may see page H, where the number of votes, the top 25 candidates has been shown. More than 1,300 votes were secured by each of these petitioners. They were 20th and 21st. So, my lords, in case these co-opted members are over and above the 25, they will be elected. My lords, I am saying that, my lords, it should be left to the wisdom of the voters, because.
Thank you very much. Thank you. No case to entertain the writ petition. We are all dismissed. Item 20.
My lords, then, my lord, I may withdraw the petition, my lords, to avail any other
Now,
remedy.
you first, we were permitting you can. Now, we are
I'm only asking, my lords, my representation may be considered.
No, we will not consider, because we don't have
Maybe either
this
accepted
problem
or
on
rejected.
pan-India basis. The people have started thinking as a right. The concession with great difficulty we obtained for you people. Now we want to convert into an enforceable right.
In this, my lords, in
Thank you very much.
Constitution
No
bench,
argument. We don't.
my lords have said one, my lords, aspect. While hearing of that Sardar Sayadna case, all stakeholders would have been invited, should have been invited, my lords. In the same, my lords, same scenario, all stakeholders, not only the Bar Council, the contestants and the voters, those views should also be taken before passing, my lords, the order.
No case to entertain the petition made out. Item 20.
Please, Your Lordship. It's a small indulgence which I thought is necessary. In terms of Your Lordship's direction in the order at page 70, can you turn to our application? First, the very small clarification, because we have been receiving lots of representations from judges who retired post 2017. So at page 68, the recent judgment in 2025, page 68, we'll have that page, paragraph 76.
Paragraph 76, yes.
Yeah, that's right. So it says the Union of India shall pay full pension of 15 lakh to retired Chief Justice, and it shall pay full pension of 13 lakh 15,000 to a retired judge of the High Court, other than so and so. Then finally, at page 71, paragraph, subpara 10 of paragraph 76.
Yes.
It's further directed that all the arrears payable to the retired judges so and so shall be calculated in accordance with the aforesaid directions, and the same shall be paid to them, along with interest at 6% per annum from the date of their entitlement. So the question today is, the pay commissions have been periodically revising the quantum of pension. These 13 lakhs and 15 lakhs happened after the 6th, 7th pay commission. Now, therefore, this should be paid with reference to the date on which they are entitled to this actual quantum is the only question. Because in 2004, when an earlier occasion whether a member from the bar was eligible to count a certain notional period for the purpose of computation of pensions, this court held in their favor, and will not kindly see turn to a repetition, sorry, application for clarification at page paragraph 4 at page 4. So that was a writ petition filed by one of the members of the bar who was appointed to the court. So Justice so-and-so, para 4, a retired judge of the Andhra Pradesh High Court, this Honorable Court prescribed 1/4/2004, the date of insertion of Section 13A of the 1954 Act, as the cutoff date for grant of benefit in terms of the judgment dated 31/3/2014. Then that part of it is set out below at the bottom of that page. For pensionary benefits, 10 years practice as an advocate be added as qualifying service for judges elevated from the bar. Further, in order to remove arbitrariness in the matter of pension elevated from the bar, the release as mentioned above ought to be reckoned from 1st April 2004, the date on which Section 13A was inserted by the High Court and Supreme Court Judge so and so, so and so. And then what happened thereafter, paragraph, can you turn to paragraph 6? So following the judgment, Section 14A came into be inserted by an Amendment Act of 2016. In para 6, we say like this: provision above came into force retrospectively with effect from 2004. Consequently, pension for all the covered instances were calculated afresh, and 10 years of service is added to the actual service of retired High Court judges. However, in the case of judges who retired prior to 1/4/2004, pension was fixed notionally, and arrears of revised pension were calculated only from 1/4/2004. No arrears were payable for the period prior to 1/4/2004. That is what we have stated. The question today now is, having regard to the revision of the quantum of pension.
Mr. Attorney, the only issue is of the cutoff date that.
Exactly. In our understanding, if the pay commission, I'm sorry.
Clarify the date.
Ideally, it should take place from 1/4/2004, as the Learned Attorney General says, and not prior to that, because Section 14A conferring equal parity of the.
That's true, Ms. Parmeshwar. Only one problem is about the quantum. The quantum was different prior to 2016. So therefore, when this court says 13 lakhs 15,000, that quantum came into effect only from the pay commission recommendation. We can't put it back to 2004.
That will be only from 9th October 16.
That's right.
See, let's not forget, if we try to take any liberal approach in the case of judges, this order will have to be applied in case of other employees also come to.
Exactly. That's what is coming to the government's mind. That's right.
Very careful in these things. Isn't it good?
The quantum.
The quantum of pension depends on the date of retirement. Earlier, if we had.
That is what we are saying.
Earlier, if we had retired.
The entitlement accrues on superannuation. So
correct.
If superannuation was before 16, then the entitlement up to 16 enhancement will be at that reduced rate. And then he will again get from.
Absolutely. That's right.
He can't get more by a judgment than what he was entitled, because the judgment says date of their entitlement. So whatever they were entitled at which date will be the computational graph.
2006, post 2016, 13 lakh.
What will happen? A person has
16, whatever they were getting, equally entitled.
Otherwise, there may be a hostile discrimination between a person who is no longer available to draw pension post 16 and a person who draws pension post 16 but had retired prior 16.
That's true. In fact, tried to look into it. I think the government gave me instance of 31 persons who retired post 2017. So in all their cases, they will get their entitlement from 2017 on the modified quantum.
So the modification will be from 16.
That's right.
This is one MA minutes. There is also one contempt petition minutes that strictly does not arise from the judgment. The main judgment concerns only judges of the High Court. The contempt petition today, which is being filed, Milods, is on behalf of a CAT member, Milods, a fact situation which is not concerned by the
separate. We will deal with that separately.
My lords, as far as that petition is concerned,
We have heard Honorable Attorney General for India, as well as senior counsel representing the former judges, some of the former judges. You are the amicus.
Amicus, yes.
As well as the learned amicus. Para 76, in bracket 1I, 2I, and Roman 10 are clarified to the extent that the revised full pension mentioned in para 76 in bracket 1I and 2I shall be admissible with effect from 9th October 2016. Shall be admissible with effect from 2016. The arrears shall consequently be computed accordingly. In the event a judge had retired before 9th October 2016, such arrears shall be calculated on the basis of pre-revised pension.
That's right.
As was admissible under the rule.
Correct. That's correct.
Shall be
Then again that year will come
on the basis of pre-revised maximum
pensionable age. Maximum pension admissible to every judge.
shall be computed on the basis of pre-revised maximum pension
admissible to the judge or the chief justice.
To the retired chief justice.
Judge or chief justice as
Retired admissible to the retired chief justice or judge as the case may be. As the case may be.
That's fine.
Now, in the case of this another gentleman, just find out, Mr. Attorney, what is to be done.
I'll look at it. I'll look at it.
We'll take up your matter. Let
Very
him
well.
have-
Very well. Very
एक डिस्पोजल हो गया सीएटी के जुडिशियल मेंबर है ना उनका पेंडिंग रहेगा बात
Item 21, my lords. I have
Item 21, my lord, I have received instructions.
Yes.
My lord, this is that Bangladeshi, my lord, Indians, my lord, or Bangladeshi, that
So,
issue.
yes.
My lord, yes, my lord, my instructions are,
Yes, sir.
will bring them.
State in your case, sir. He will have instructions.
Please. Lord, the government would bring them back and thereafter examine their status, my lord, and depending upon the outcome, my lord, take steps accordingly.
That's it. That's it.
Please, my lords, your lordships may record that and, and keep it for after they come back. Keep this matter for after they come back. Then it may be disposed of. That's all. Let them be brought back to India first.
Only one request, my lord, your lordships may record my statement that this is in peculiar facts of the case.
Yes.
And without making it a precedent.
Yes, Solicitor General of India submits that keeping in view the peculiar facts and circumstances of this case, and by not treating it as a precedent to be followed in other instances, the government of India has decided to bring the respondents back to India and thereafter to verify their claim of Indian citizenship. Also, the necessary consequences of their uh, con- uh, continuation in India shall depend upon the outcome of such inquiry.
Please.
Any estimated time, Mr. Solicitor?
My lord, it generally takes, my lord, 8 to 10 days. Your lordships may consider having it after vacation, my lords.
When Solicitor General points out that the respondents are expected to be brought back within 10 days, post this matter in July opening after 1 week.
Immediately on the reopening, my lords. That's all. So that it can be disposed of if things go well. Otherwise,
Yes, we are listing it immediately opening.
I'm grateful. I'm grateful, my lord.
Please, sir.
Grateful, lordship.
Item 22, any urgency?
Not
Item-
urgency, my lord. Not urgency.
Now we will take up after some time. Item 23. Item 23.
Yeah,
Lord,
well, it's item 23,
there is considerable urgency from our side.
The NCRT, madam.
Yes.
Well, I'm appearing in support of Michael Danino, and this is in support of an set of IAs 105, 382 and 383, which we filed. It's a fairly detailed and comprehensive
I appeal
IA.
for this. So sorry.
And there's a restricted request on our part.
Just a minute, where is Mr. Solicitor?
I'm here, my lords. My lord, so far as the government is concerned, my lord, our decision is that we would not like to associate them in future, my lord. For rest of the prayers, my lord, it is entirely your lordship's prerogative.
And Mr. Solicitor, you.
But there is one thing more, my lord, which I wanted to bring to your lordship's notice,
Yes.
my lord, not concerning this. But I came across, my lord, one more, my lord, such instance in standard 11 textbook. Lord, there are some, my lord, cartoons which are printed. Cartoons per se, Lord, cannot have any objectionable part. But these are the cartoons printed in a context. And for the age group which is impressionable, Lord, it may not be Lord, proper to have these cartoons in a textbook. Textbook is not a space where, my lord, you use cartoons.
But Mr. Solicitor, then we will not say anything. What you can do is, you may refer it to the committee, because now the committee is headed by a former Supreme Court judge.
Yes.
Sister Justice Sindhu Malhotra is looking into this aspect. And we may request her to continue with the same committee, or if she wants any other composition, she may be given.
My lord, in consultation, my lord, suppose some member has some, my lord, issue, in consultation with my lord, our ladyship Justice Malhotra, we will, my lord, we can always replace, my lord, or substitute rather. Your lordships may kindly consider recording my statement for standard 11 textbook.
We are just reverting back to you, Mr. Diwan, in a minute.
Yes, certainly, certainly.
Write down.
Can I respond? So sorry.
We are not closing.
Where?
The London Solicitor General of India points out that he has come across some cartoons, etc., contained in the NCRT book of 11th standard.
No, it is textbook for grade 8, part 2. Your
Textbook.
lordships may say some state, my lord, textbook. my lord.
Some textbook published by NCRT, which, according to him, also required to be revisited, reviewed by the expert committee constituted by Government of India, and which is headed by Justice Indhu Malhotra, a former judge of this court. The Netherlands Solicitor General submits, and rightly so, that the said textbook also shall be referred to the Committee of Justice Indhu Malhotra, who may review the said textbooks to the same composition of the committee and or she may suggest the reconstitution of the committee to the government of India, from whereupon an appropriate order of reconstituting the committee shall be passed. Then say, ordered accordingly, let the entire issue be placed before Justice Sindhu Malhotra, former judge of this court. Next paragraph. Now, Mr. Diwan,
Yes. May I just make a suggestion? If your lordships could just take up, it's one paper book, it's IA 105382 and 105383. The applicant before your lordship is Michael Danino. Your lordships have that? And I believe your lordships must have gone through this application as well. So I'll just point out, take you straight away to page 34. Justice Pancholi has it?
Mr. Diwan, the impression, because the impression which we have at least tentatively or prima facie,
Yeah.
we have gathered is that there is no question of doubting their, the long journey of in academia and each one
Yeah,
of them.
I'm grateful. Yes, yeah, I think so.
We have earlier also said so.
Correct.
Now, probably they are saying that in addition to them, there were other people also involved in
No,
this attack.
it's not just that, Manoj. It's the whole process. I'll explain it. So just see what my request is, because I'm hoping this doesn't require an argument. If it does, of course, I'll place it right away. But just go to page 34, because I have I believe, a fairly modest request. Page 34. I think this is best addressed without an argument. But please just look at it. Your lordships have page 34 of my application. So the prayer is a request for modification of the 11th March order in terms of para 31 of my application. And the only request in para 31 is that this adverse statement in paragraph 8, your lordships may consider deleting.
Thirty-one, you have said yes.
Your lordships have para 30, page 34.
Page 19.
So page 34, the only request is in terms of para 31, and para 31 refers to your lordship's order of 11th March 2026 and paragraph 8, which you will find at page 19 of the paper book. So may I request you to just glance over page 19. You recall that this was an ex parte order which was passed. Just have a look at paragraph 8. It's on page 19.
Yes.
Now, first, it's ex parte. Second, I'm sure your lordships have had the advantage of going through my application and how the process goes about, how it's a completely collective responsibility. There is no individual authorship. In fact, the position is to the contrary. So in these circumstances, your lordships may consider...
When I was saying that the prima facie impression which we gathered was only because of para 31, where you say, and maybe rightly so, it seems that you are right in saying that you are not the word used by you holding them solely responsible.
Well, let's not remove that. Just keep that. Just see what has happened after that in para 8. I don't want to even read it. I don't want to read it. Paragraph 8, your lordships have page 19. This is an ex parte order. These are people, the most decorated academics who are there. Please look at paragraph 8 and the far-reaching consequence. So I am just saying, please suspend this for the moment.
the, like this, we have two Sri Diwan, Shankar Naran and Shanti Put senior counsels in support of the prayers made in their respective applications. Seeking the modification of para 8 of already noticed. March 2026. While we reiterate in known certain terms that the curriculum contained in the textbook of class 8 published by NCERT was wholly undesirable and necessary remedial steps for
We were a member.
the insertion of two contents, insertion of the two contents in relation to the Indian judiciary has already been taken by the Government of India by constituting an expert committee headed by none else than a former judge of this court. However, owing to the explanation given by the applicants, we deem it appropriate to modify para 8 of the order and clarify that to modify the para 8 of the order and recall the direction given to Government of India, state governments of the Union territories or other universities and institutions disassociate the three applicants from the academic activities. In this regard, we leave it to the Union of India or the state governments, state governments or the other authorities to take an independent decision without being influenced by the observations made in para 8 of our above stated order. It is clarified that this line similarly, the opening line in para 8 of the order, to the extent that the three applicants acted inverted comma deliberately and knowingly misrepresented the facts dash in order to was closed. It is recalled in view of the explanation rendered by them. Consequently, it is clarified that the
Only one fact, my lord, I would like to mention.
Collective decisions.
My lord, I would like to take, my lord, may mention one fact. My lord, my instructions are, this chapter prepared by Mr. Diwan's client was never placed before, my lord, the committee. It was shared with by my lord email to 3 or 4 members. So it's not a collective decision. So government would like to on its own, my lord, take a decision not to associate them, my lord, any further in any of these activities.
That's why we are
Your
saying
lordships
that
have said those decisions can always be taken. That's the direction of the
mention
Supreme Court goes.
collective. However, we may listen to it that according to Learned Soliciting of India, the curriculum prepared by the applicants was not prepared before the complete body,
all members of
before the complete body at all levels, and as such it cannot become as a collective decision.
Yes.
So be that as it may, we leave it to the entire discussion of the government of India to take an appropriate decision.
Manoj, we have some reservation about the observations that have been made about the individuals themselves. In both orders.
Mr.
I'm sorry.
Chappanaran, we have deleted that.
I'm sorry?
We have deleted that.
No,
Para 8, the fact attribution of motive.
No, Malad, the first sentence, your lordships will note, you've said at the outset, we have no reason to doubt that Professor so-and-so do not have reasonable informed knowledge about the Indian judiciary and or they deliberately and knowingly. This entirety, I mean, these are people with some substantial
knowledge. You can't deny probably that you had knowledge about Indian judiciary.
No, of course we did. Of course we had knowledge, which is why.
Deliberately and knowingly we have deleted.
Lords, but the fact is, this seems to suggest that they don't have the knowledge. Either they have the knowledge or they don't have the knowledge. If they don't have the knowledge, it can't be
The chapter
malicious.
suggests.
Just 1 minute, Mr. Mehta. Well, but when they do have the knowledge and what they're saying is not deliberate or malicious at all, what has happened is, and I think we should show your lordships that in fairness. My lords, I'll tell your lordships honestly, when there are small powder kegs which are there in the newspapers and in the media every day, there are people very keen to come and make a big deal out of it and light a match under it. That's what has happened in this case, unfortunately. I was present when it was mentioned with a lot of drama at that date, and it seemed emotionally that all of us would get affected by it. But when you go through it and you see that in the class 6 textbook, questions have been raised and small issues that everybody reads. Children from the age of 10 start reading newspapers, my lords. And when you see stories, we need to give a benign explanation for it rather than make it sound worse. If your lordship sees the entire chapter on judiciary, it follows up on previous 6th standard and 7th standard references to election commission, elections, issues with parliamentarians, issues within the executive. All that is raised in 6th and 7th standard. In 8th standard, in the first part, we have other issues dealing with administration, roads broken, etc. In 8th standard, when we came to the judiciary chapter,
You must have seen the language and the expression used. Anyway, we don't want to say that this part we have deleted only because of their explanation. That's all.
but also the previous order for a minute, if I can show your lordships. That's the 26th February 2026 order. I just want your lordships to just note at para 5, on a prima facie examination, that was prima facie, my lord, at that point, your lordship didn't have our explanation. If I can just read that. On a prima facie examination of the book's contents, when read in conjunction with the administrative response received from the director, NCRT reveals a discernible underlying agenda to undermine the institutional authority and demean the dignity.
We are not saying members, we are saying NCRT.
But this chapter having been prepared by us and having been, yes,
it is prima facie.
Yes.
And the conclusive opinion,
yes,
that there is an attribution of motive to your client,
yes,
is being deleted.
If your lordships can observe that.
That takes care of the conclusion not being a part of the final order.
Very well, Manoj, because
we believe the observation that it was deliberate, knowing misrepresentation to tarnish.
And we have literally
That's
banned
totally removed.
specifically.
We have also we've also
yes,
set aside the direction that nobody should engage
yes,
with your
yes,
client.
that direction, because
it is left to the independent decision of the constitution.
Yes, because I'll tell your lordships honestly,
academic entities.
When your lordships make observations like this, it has massive impact across the country. Many states come running to show that we are good students, we are obeying, we are disenfranchising them immediately.
Conscious of the
Yes.
seriousness of the observation,
Yes.
and that is why the last 3 lines of that paragraph kept the window open for the deliberation that we are having now.
Very well, Manoj. Manoj, once again, I want to make it clear on behalf of our clients that there was zero intent at all. I think sometimes.
That is why the explanation we are accepting.
Yes.
That probably they did not have any bad
Because,
intent.
Manoj, it's only in our universities and our schools when we debate issues that maybe solutions will come, education will come.
Let us put it this way.
Yes.
We completely are in agreement that there has been certain areas where the judicial role of judiciary has been highlighted.
Yes.
There have been areas where challenges to judiciary has been given.
And positive things, Manoj, also.
There's neither, we're not looking into positive or negative. We are seeing whether it's a balanced side.
Yes.
And we felt it was lopsided.
Very well.
One.
Very well.
Anyway, I'm very grateful to the court, Manoj, that without having to enter into larger issues of debate, your lordships have made that modification.
Yes.
Role of judiciary.
Yes.
Preserving constitutional supremacy.
Yes.
Was completely missed. On the other hand, corruption was highlighted as an unique feature of
I won't go into it because your lordship, but the entire chapter, if you see the chapter, my lords, there are 14 pages devoted to judicial review and the good that your lordships have done through public interest litigation. 1 page devoted to Justice Kuldeep Singh as the green judge and all loads on that. And then finally, arrears and judicial corruption dealt with.
What about access to justice through legal services? Not a single word.
No, there may be topics that need to be referred to.
The title was Justice Delayed is Justice Denied. That was the title.
Yes. But there was nothing to say about judicial the role of judges in legal services and access to justice.
That's there, my lords. That's there. There are 2 parts to the class 8 textbook. Judiciary is dealt with in both parts. So the problem is when a child is going through an entire year, he will see all aspects of this. But the challenge is, because now, my lords, what has happened is, I feel that we are tending to whitewash our own institution. I don't think children should be subject to that. Let's have it what's and all. Every institution has problems.
Whereas, can I just make one final request on the part of my the applicant? I'm very grateful for the order which is passed. When your lordship is finally, just before signing it, just please have a look, because I think the concerns which Mr. Gopal Shankar Narayan and all of us have expressed are real concerns, because these are academics of distinction. So if it requires some small change, etc., we would be very grateful if your lordship looks at it.
That Mr. Diwan, please be rest assured, the observations will be in context of the content and not the individual.
Yeah, I'm very, very grateful, Manoj. That's exactly what I think it should be. I'm
very brief intervention.
Just half a minute. I just want to answer my lords, Justice Bagchi. In fact, at page 19, some state governments have set up mobile courts that travel to villages to hear cases and deliver judgments at people's doorsteps. The union government has also attempted to reform outdated legal procedures through laws such as BNSS to help courts speed up disposal of cases. And then to further reduce delays, courts increasingly encourage litigants to settle disputes through conciliation or mediation. In such cases, party meet with conciliatory. I'm just saying.
You only read in your office while sitting the entire book, and then
I've read 4 books, not only this chapter. I've read 6th, 7th, 8th, 9th. I've personally, my lords, taught legal studies for 11th grade and 12th grade from these very textbooks. And I can tell you, there are many chapters of those other textbooks which are so completely wrong on law. But unfortunately, I've been forced to teach that because eventually they're going to be graded on the textbooks. There may be many textbooks which need revision.
Senior members of the bar to contribute to legal education,
has to be
writing books for the students in class 10 and
just the last year, 11th and 12th, I've been teaching legal studies. I know what the challenges are.
We would appreciate
this. I think this takes care of. Lordship's order takes care of.
Can I just take 30 seconds, not beyond that? I represent Ms. Suparna Devakar. In Mr. Michel Danino's own affidavit in para 22, he clearly says my role is limited only to that of liaising. The issue what has happened is after that, of course, the government is free to take its own decision. The Karnataka government has now issued a circular effectively saying 31 of its institutions will not be associated with the 3 of us. And there has been a second order effect. I have actually served in this field for 30 years. Mr. Michel Danino is a Padma awardee by this honorable state, and he has been a member of the Indian Council for Historical Research. As students of law and students of history, we have read his books as far as Bharatiya Sanskriti is concerned. My only request is this: there is no malafide ever intended whatsoever. Kindly consider perhaps even declaring to some effect so that the second order effects are dealt.
To the extent possible, we have done it.
I'll leave it to my lords. I'm grateful for the deletions from the previous order. I'm only saying protect them because their hard-earned effort and their years of service will effectively, because if the union has taken this decision or chooses to take the decision, it will have an impact.
We are again.
But I leave it to the union, of course.
We are again reiterating what we said to Mr. Diwan.
Please, please.
Our comments are with the contents,
please,
not with the creators.
Unfortunately, that's not how it's been reported, Miraj. That's the problem. And perception matters, unfortunately.
Do we have control over reportage?
All I'm saying is, my lords has seen that
And
these
we
proceedings
would, we would as request you to create this climate as to a soberness and a degree of maturity in response to judicial proceedings and judicial orders.
I'm with my lords completely. And
Rather
in fact, we are
than
against any kind of
sensational.
sensationalist reportage that happens on a daily basis. I'm with my lords.
Sensationalism be a part of reporting information. But as the dialogue which takes place in the court between a senior counsel and judge should not really be anything to do with what is contents of the report.
I understand. Can I make just one submission?
It's always on a different context, Manoj, but you lose the context and take away something.
Because of the reason that concerns, we knew that the observations were harsh and had several consequences. We gave the opportunity to respond, and in response to that, we are deleting these portions.
Please. So one limited intervention, leave it at that. Could my lords record as part of the order that based on the affidavit of Mr. Danino as well, my role was limited. Kindly capture only that aspect. I'm not pushing anything further. That will help us. Because of course, my lords cannot be responsible for perception. I'm only requesting my lords to protect us from perception. That's it. Nothing else.
It is impossible. And if you get carried through perception in what people feel and people say and people do, of which we are the strongest votaries and supporters, we will be actually walking up the garden path.
I leave it, my lords. I'm grateful.
Just that.
Yes.
Obliged to your lordship.
That previous order, para 6, 7, 8, if you can pass one sentence, while it's prima facie, para 5 is prima facie, para 6, 7, 8, my lords, it says, it seems to us that the choice of words and expressions in the book may not be a simpliciter, inadvertent or bona fide error.
That's the only.
That your lordships have said in para.
Of the book, not of the individual, Mr. Gopal.
My lords, but eventually it comes down on us as having prepared it.
Now it is it out in the
Mr. Deepak's client may have had a lesser role, but for these, because your lordships are a court of record, my lord, this is for posterity, Article 129. So my problem is, if these paragraphs also, if one sentence can come that these observations are prima facie or maybe in the past, whatever it is, it will help. Because as academics, my lords, they have no protection.
We will see. We'll go through again.
No, but we are very grateful. I completely join Mr. Diwan, my lord, that your lordships have kindly
and
accepted
some of
our
these people are primarily employed by the government. That's the only issue. They'll even lose their employment and livelihood. That's the issue, my lords. Please consider this. Primary source of employment is to act as consultants to the government. That's all. I leave it to Miller. So grateful, deeply obliged.
Grateful.
Deeply grateful.
Obliged to lordship.
Mr. Sibbal, it seems that we'll be able to start on 2 o'clock only. As strongly desired by you.
No. But I got all the turns.
You were here before 12:30.
12:15 I was here.
Exactly. That's why we are saying that you were before 12:30.
But very kind of your lordships too.
Well, as your lordship is rising, item 37 is always meant to be a non-miscellaneous. It's coming on a Monday, Friday always, lordship may consider that. It's a disposal matter.
No, before that we are just, that's why, because we are left with around 3-4 minutes, we just thought,
Give some date in July, Tuesday or Wednesday, whatever.
And item 30, who is there in contempt petition?
Lord, 24.
At 24, we'll take up on some other date. Huh?
Item 25.
Lord, the bodies which are.
Progress done?
My lord, they
Yes,
have
my
filed-
lords, we have filed a detailed status report, my
They have
lords.
filed a status report, if I may put across something. My lord, the bodies which are coming back, they are mutilated to an extent that they are unrecognizable. It is just a mush of flesh and bone. The
My lords,
families.
this is not correct, my lords. I have filed a detailed status report.
DNA test.
These are the directions which we are seeking, my lord. His lordship may order them to.
Government will be fully conscious with regard to the
My lord, they have
tools
not collected
necessary
DNA.
for identification.
They have
My
not
lords,
collected-
we are doing that. The DNA reports are being sent to the Russian authorities and they are being correlated back.
How
My lords,
Madam Asuriya, how many are still left and what efforts are being made? Any?
15
so, my
are
lords, about 217, my lords, Indian nationals had joined the Russian armed forces, my lords. After the diplomatic engagement, my lords, 139 nationals have been released from the contractual engagements, my lords. 49 nationals have lost their lives in the conflict, my lords. And 6 nationals have been confirmed missing. This is the statistics that we have given in the status report for each of the 26 individuals that have filed whose family have filed the present writ petition. Their status has also been given, my lords. These 26 are unfortunately, my lords, their status is 14 cases pertain to death and 11 individuals are missing in action. One is actually incarcerated in a criminal case. So, my lords, the mortal remains of 8 have already been brought in and given to the family members.
My lord, the
One family
members
has
say-
given us the DNA. I've filed a detailed status report for each individual, my lords.
My lord, there is also this aspect of compensation. The Russians are wanting to compensate. They have written to us. The MEA has written to us that you fill up this compensation forms. They do not follow up. This is our trouble.
No, my lords, we are facilitating that also through our consular and diplomatic measures.
Lord, there is also this agent issue. His lordship would have seen the videos. They have specifically named these issues. We cannot mollycoddle them to an issue to the extent that we take them to the house of these agents. We have given a comprehensive list. They have the names. They have the mobile numbers of these persons who we are accusing. What more
Anyway,
can
now in response to status report, if you want to place on record something, you can do it.
my lord, Russians are wanting to compensate around 1.5 crore rupees plus 40,000 rupees of pension per month.
We do not know who is promising and who will give you. If they want to give you pension, let them give it. Who are stopping?
Please, the MEA
Has given full description of the 26,
on this part.
Alleged the 26 migrants who had gone to the 26 persons of Indian origin who had gone to.
Let the matter be listed before the vacation bench, my lord.
As regard
It's a very sensitive matter.
As regard to the any consequential benefits to which the subject persons or their family members are entitled to. They may submit such claims meanwhile, which will be considered by the authorities in accordance with law. In accordance with law, post this matter, take further consideration on today.
Grateful, man.
And the kind of endeavor they are taking, my lord, to help us. I must inform his lordship that before coming to court today, this morning, I had to make calls to my clients, the writ petitioners, that your people have passed away. Because it was only last night that they have filed a status report.
My lords, it's very unfortunate that my colleague is
does not even have the
sensationalizing
decency
this like
to
this.
make a call that your people have passed away.
We have
It was
received
me
an
who
email
informed them
that
today. As these proceedings are going on, my
lords-
lord, there is a shok sabha, there is a prayer meeting which is going on in their houses.
my lords, it's very sad that my colleague is sensationalizing this.
The CPCB's report has come completely favors us. It says that without following the CPCB guidelines and having a gap analysis report, it should not have been bifurcated and distributed further.
For the PCB, this is incorrect. I'll file my affidavit.
25.
35 we will see, not today because we some counter affidavit has come.
They have CPCB has filed a reply.
I'll file my affidavit. I appear for the State Pollution Control Board. I'll file my affidavit. Lords, we are complying with the CPCB.
Anyone in item 26, what happened? What is the status, Madam Asuriya, in item 26?
Give some date. Sorry, apologies. 25 some date.
My lords, the cat will move during the vacations, my lords. 75% work is complete. If your lordships may call it in July, we will report, my lords, that the transfer would be complete.
The tribunal has been shifted to the new building.
No, my lords, they are not shifted yet, but in the vacations they will be shifted, if your lordships may call it after July.
Learned relations will inform that the tribunal is yet to be shifted to the new premises. She seeks more time to have latest instructions. Post this matter in the third week of July. Then item number 29.
27, my lord, can be disposed of.
28, there is no such urgency, but there is one in 28, my lord, that RERA authority in Himachal that shifting, my lord, your lordship, that only one correction is needed, my lord, in the order of 12th of February 26, where in the last, second last line, my lord, where your lordship wanted to vest the jurisdiction from the learned district judge Shimla to Dharamsala, the word instead of adjudicatory power has come appellate power. Appellate power would be with the tribunal. So somebody has moved an application. I'm supporting that application. The order dated 12th of February 26, which your lordship passed in the second last line order. My lord, what happened? Shifting from Shimla to Dharamsala, your lordship permitted. So jurisdiction of adjudication had also to go to the district judge, Dharamsala. The word, unfortunately, in para 4, second last line has come appellate power. Appellate power is not with the learned district judge. That is what your lordship meant was adjudicatory power. So that appellate will be substituted by.
Just a minute. On being pointed out, para
We have no objection.
4 of the order of 12th February 2026 is ordered to be corrected. The words inverted commas appellate powers shall be read as adjudicatory powers.
Yes.
Adjudicatory powers.
And secondly, yes, that would suffice the purpose for the time being. My lord, your lordships have indicated let the High Court hear the matter because we have some contentions to make.
So the then we can dispose of this.
The shifting is almost complete. It is going to be shortly functional. So, my lord, at this stage, my lord, I think it should complete. Your lordships have permitted us to shift the data. Appointments have been.
Ask me. My lord.
Intervention today still by some architect. Now, he may not have any.
The architect filed that application for this clarification.
So what is this problem, petitioner's problem?
No, my lord, there is no, my lord, your lordships have transferred it. My lord, the state wanted to get it transferred to Dharamsala. My lord, your lordship permitted it. The matter is to be heard on merits. We are not.
No, what is that merit we want to know?
My lord, only 5% of the work is there in the Dharamshala district. The rest is, my lord, in Shimla, Solan, and my lord, other districts.
Policy
I
decision. I don't think we
and
can
my lord,
not decided like this.
just permit 250.
For the Himachali will fight like this unnecessarily.
250
and unnecessarily.
Well, look what I'm up against.
My lord, the flat by 250 kilometers in hills, my lord, takes 6, 7, 8 hours. Your lordships have stayed there, lordships are aware. My lord, the individual complaint which are being in Shimla, because 90% of the projects are registered in Shimla, right to access, my lord, in our respectful submission is to be considered either your lordship may consider or High Court consider. We are not saying that we should be considered here. Your lordships have indicated in the first order, except for this part for the timing, let the High Court decide the writ petition on merits.
My lord,
They are left in merit.
My lord, there are.
I have not even put my case. The matter was not called.
I have no problem, my lord. I have no problem. My learned friend can complete it. I can say it afterward. I have no difficulty.
Very well considered policy decision. I think it can be taken up on any day convenient to my lords, and it can be because there are many offices which are being shifted out of Shimla to decongest Shimla. This is a very well deliberated policy decision at a very high level. And my lord, the idea is also that there will be less and less building projects perhaps in Shimla itself, and they may move elsewhere.
I think these Shimla members, they know it very well.
This
time, the state tribunal has not been constituted state administrative tribunal. Otherwise, the practice was that if there is a for service matters, if the state will have a state administrative tribunal, it has always been in Dharamshala. And the High Court has been operating from Shimla right from the very beginning, because seat of the High Court is in any case Shimla. This time there is no tribunal constituted. So the litigation which used to be there for Dharamshala bar and something, probably in entire shifting, some minor work has gone to Dharamshala.
I am not saying, my lord, you're in Haryana, which is a smaller state, there are 2 RERA authorities because the Act empowers it. And therefore, in Maharashtra, there are more than 3. The RERA authorities, because of the development.
We don't have any great impression about these authorities. So
My lord,
let's
that
not talk about.
My lord, that we are always hopeful, my lord, the things will
It's a
improve.
burden on the state exchequer, Mr. Singh.
My lord, I have only one submission, my lord. Somebody has to hear this matter. Your lordship may hear it. I have no difficulty. We didn't want to come in the way in any manner. Let High Court decide it.
Madam Madhvidwan, you create online facility so that the lawyers in Shimla, they can file the cases online and they can argue the cases.
Absolutely.
That will be fine.
Please, Your Lordship.
Absolutely.
My lord, your lordship may just see the first para, the para 3 of that order of 12th of February 26. This interim arrangement of stay for the shifting in the timing was subject to final order. We have my lord, few contentions to raise before your lordship. Whenever your lordships have time, please, your lordship may hear, or your lordship said High Court will hear it. Kindly see para 3, my lord.
The issue that had arisen for consideration before the High Court was whether the state government should be permitted to shift the office of RERA RERA Himachal Pradesh from Shimla to Dharamsala. Next paragraph. It seems that the shifting of the office has been opposed primarily on the ground that the complaints pending or being filed before RERA are mostly pertain to the area in and around Shimla, and therefore it will cause extreme hardship to the complainants or the advocates representing them to travel all the way from Shimla to Dharamsala for pursuing such complaints.
So 90% of the projects are in and around Shimla, and the consumers who will seek the remedy, not only advocates, my lord, the people who have to approach the trust.
And the consumers and advocates will have difficulty. Next paragraph. It goes without saying that shifting of the headquarters of an office stroke institution is essentially a policy matter, and if the elected government decides to shift an office from A place to B place, we see hardly any scope of judicial review of such decision. It is in this backdrop that while the interim order dated so and so, the interim stay passed by the High Court was stayed, and the state government was permitted to shift the RERA office from Shimla to Dharamsala. Next paragraph. Ms. Madhvi Diwan and Senior Counsel for the state of Himachal Pradesh informs that most of the work for shifting has been undertaken, and the office will become functional at Dharamsala very soon. Next paragraph. We are also conscious of the inconvenience that will be caused to the project proponents, stroke home buyers, stroke other complainants, especially the advocates representing them from Shimla, who might face difficulty in traveling to Dharamsala. In this regard, we direct the state of Himachal Pradesh to set up an online portal for filing of complaints at Shimla, and also to ensure virtual hearings stroke online facilities in the office of the RERA authority at Dharamsala, thereby permitting the advocates of the complainants from Shimla region to appear online for the purpose of pursuing their complaints, stroke cases filed by them. Such an arrangement, we are quite sure, will redress the grievances of the petitioner or other affected persons in and around Shimla. With the directions, we see no logic for continuation of the proceeding before the High Court. The petition, so and so, the CWP IL number 38 of 2025 accordingly stand disposable.
Please, Your Lordship.
My lord, your lordship may just reserve the liberty, my lord, if anything arises in the difficulties which may be faced by the consumer, we can always approach the
by any stakeholder. So my liberty is granted to approach this court.
My lord, wherever you, my lord, what I am respectfully submitting, my lord.
State authority. Let them go to the to seek redressal of such grievances before the competent authority. The state government will ensure that if any genuine issue arises, the same is resolved immediately, is resolved without any delay.
Grateful.
Please, grateful.
Any item 29, any urgency?
There's no urgency in 29. Your lordships can have it later.
So 27 can be disposed of.
29.
29.
29, this is a state appeal, against a prosecution which has been quashed. Can your lordships may have it after vacations?
Yes, we are taking up.
May have it on a non-miscellaneous day,
My lords had called out 30, my lords.
Item 30, yes.
30, my lords, I am for the petitioner.
Yeah.
This is that Madhya Pradesh matter, my lords. My lords had issued notice returnable in July, my lords.
Mr. Jain is such a responsible lawyer, we never thought unnecessarily. Where is Mr. Jain?
The original order had made the notice returnable in July, my lords, though I think service is complete.
Oh, original order is in July.
In July. Original order was in July.
27 July.
Yes, my lord. Yes.
All right. Now we will take up no other matter apart heard. We'll take up the part heard matter. 31 to 37, some arbitration.
31 to 37 should go, Malus, to July. 37 should go to July, Malus. 37.
We are on opposite sides.
Even 31 can be post vacation, your lordship. There is no such urgency.
Well, same for 34.
36.
37, Dr. Singhvi and I are on opposite sides. I think we are.
It should go to
all
post
agreed that
July.
it will
Only
go
thing is we both expect it
37.
to be on miscellaneous day. 37 months. Please put it towards the end of July or August.
Item 36.
All matters now, other than part heard, are going after vacation, unless now you insist for pre-vacation.
No, we are not.
Then.
Very. Keep your
Lordship in
The
item.
model will continue wherever they are.
Lordship in item. Lordship in item 40, Lordship, there is a default on my part, Lordship. I have to file a spare copies, Lordship. We will file during the course of the day, Lordship.
Item
Lord, in item 35, maybe request any specific date, Lord. In fact, 2 months were given to them. They did not file any counter, Lord, thereafter. Any specific date?
We have already circulated. Last date is granted, sir.
Kindly.
Yes, what has it?
Pertains to Sabrimala temple matter.
Take mic.
That is already CAV, Your Lordship. Lordship, actually, due to non-cooperation of advocate on record, I'm not able to file my written submission. I'm the original petitioner in Writ Petition Civil 373 of 2006 and respondent number 4 in 2018 review petition. So, Lordship, may kindly take. Due to non-cooperation of, he is not signing, actually, he's saying to put my words and views in submission. So, Lordship, it may be taken on record as petitioner, or I can hand it over to the court masters.
In item number 36. Lordship, in item number 36, there is a formal application to take my rejoinder on record. It's a section 11. Then the
Check mic.
Your Lordship, may I mention? May I mention, Your Lordship? May I mention, Your Lordship?
Yes, please.
Your Lordship, there is some urgency in the case, diary number 31845, Your Lord, 2026. So, because earlier, Your Lordship, I'm trying to on VC, but unfortunately, I'm not on mandatory. There is some urgency. Kindly list the matter on 26. 25. Already filed, Your Lordship.
No, which matter are you referring to? Fresh matter?
Fresh matter.
It has been filed.
Yes, sir.
What is the urgency?
Urgency, Your Lordship, because paramount interest of the children you have all totally ignored by the contempt court to restrain to visit the outside. Mama ke ghar ja rahe the, Your Lordship. But contempt court totally overstepped the division.
If the particulars will examine it, there is an urgency, we will list.
It's yes.
Yes, Mr. Speaker.
If you like.
Well, I was referring to the compilation of documents relating to the model production sharing contract. Well, that's when we left last time. Right, Mulaz? And kindly take up that paper book, Mulaz.
This one?
This is the one. And the last time, Mulaz, I was reading clause 7.1, article 7.1 and 7.4. That's the last, Mulaz, last time.
Which page, Mr. Sibal?
Page 33, Mulaz. The point that I was trying to make, Mulaz, in the context of the issue relating to international commercial arbitration, is that in terms of the model contract itself, I have to nominate an operator. And the argument is very simple. Supposing I had nominated NICO or I had nominated BP, then it would be an international commercial arbitration. So if Reliance is nominated, it doesn't become an international commercial arbitration. So that's somewhat, Mulaz, intriguing. So obviously you can't interpret the production sharing contract in that context. That's the point that I was trying to make. Because as far as the parties are concerned, Mulaz, they are not concerned with the consequences of a nomination of an operator. So, Mulaz, and 7.4, I had read that within 15 days.
Is it page 33?
Yes.
Page
Yes.
33.
Page 33, Mulaz. And 7.4, Mulaz. This is Bakshi and Pancholi.
Yes.
Within 15 days of the effective date, or such longer period as may be agreed to by the government, the companies constituting contractor shall execute an operating agreement. The said agreement shall be consistent with the provisions of this contract and shall provide for, among other things, the appointment, resignation, removal, and responsibilities of the operator, establishment of an operating committee comprising of an agreed number of representatives of the companies chaired by the representative of the operator, functions of the said operating company, taking into account the provisions of the contract, procedures for decision-making, frequency and place of meetings, and constitution of costs, default, sole risk, disposal of petroleum, and assignment as between the parties to the operating agreement. So this, Mulaz, controls the production sharing contract, and I can't deviate from it. Now kindly come straight away to page 50. And the operator has to act for everyone. It says 7.4.1 and in 7.4.2. In case of a single company constitutes the contractor, the provisions of such and such will apply. Now, let's kindly come to straight away to page 50, page 58. Now, this is also important.
Page, Mr. Siddhu?
Page 58, Malas. Yes. Article 20.1.
Well,
But I don't need to read the entire article. Just come to 20.3, Malas.
yes.
It says a party other than a foreign company comprising the contractor shall be governed by the relevant currency and foreign exchange laws and related administrative instructions and procedures foreign domestic. So if I'm not a foreign company, then it's a domestic arbitration. Obviously, we have a problem. Then 63, 22.3 at page 63. Point 22.3 at page 63. At the request of the government, the foreign company shall separately endeavor to negotiate in good faith technical assistance agreements with the government or a company nominated by government. For this purpose, setting forth the terms by which each foreign company constituting the contractor may render technical assistance and make available commercially proven technical information of a proprietary nature for use in India by the government or the company nominated by government. The issues to be addressed in negotiating such technical assistance agreements shall include, but not limited to, licensing issues, royalty conditions, confidentiality restrictions, liabilities, costs, and method of payment.
Backbencher.
So he's not a backbencher, Malad. What he does is, Malad, he actually participates in the process of transfer of technology under confidentiality agreements. And of course, give money. Then, let's kindly come to page 69. (27.1). Yes. 69, which is why our position has throughout been, it says government, Article 27.1 at 69, the government is the sole owner of petroleum underlying the contract area and shall remain the sole owner of petroleum produced pursuant to provisions of this contract, except as regards of that part of crude oil, condensate or gas, the title whereof was passed to the contractors or other person in accordance with the provisions of this contract. Ownership of government, to the extent, Mullards, I extract, I am granted ability to sell, permission to sell, I am entitled to do that. That's all that it means. So, Mullards, the participation of a foreign company is inherent in the contract itself and in the model contract. And that is the basic assumption on the basis of which a foreign direct investment comes into this country. Mullards, I just pause for a minute because it's interesting. Mullards, your lordships, I don't know whether you saw it or not, this morning's headline news about biogas. There's headline news about biogas technology and government has set up a committee. Why, Mullards? Mullards, the 3 countries in the world that are at the forefront of biogas technology are Finland, where our Prime Minister went, the Dutch, and Norway. Netherlands and Norway. And Mullards, they have huge technologies. I myself been there when Science and Technology Minister.
All 3 Scandinavian countries.
I'm sorry? Scandinavian countries. Well, the Prime Minister was there, Mullards. That's why this has come, because the problem is we need electricity. We need all sources of electricity. And we have to get foreign direct investment, both in terms of finance as well as technology. And how it works there, Mullards, I know maybe it's an aside, but I'll just tell your lordships. The problem with India is that we don't segregate our waste. Plastics are included in all the waste. So, Mullards, Mullards, in that country, there is regulation to say every household must segregate its waste. 1 plastic bag dealing with this, 1 plastic bag dealing with this, then it's taken, Mullards, to the site, and then through technology, biogas is produced. So these are things that are going to happen. This is going to be the age of robotics. Mullards, in sanitation, for example, you don't need a man, a Dalit, to go inside, Mullards, and collect the scavengings. You don't need it. The robotics will take care of it. Agriculture, biotechnology, automation, warehouses. These are fields for tomorrow. You're going to get huge foreign direct investment. No message should be sent from the country and from the court that, look, we're going to tamper with this kind of contract and give an interpretation which will take away the rationale for coming in. Which is why in oil, we have only 2 companies coming into this country, Mullards. We have our own Reliance and we have BP. There is no third player. This must be kept in mind by all of us. Anyway, my lords, Article 30, my lords. Page 75, my lords. 30.8 at page 76. In the event of termination pursuant to 30.2, 30.3, and 30.4, or 30.4, government may kindly read B, mothers. A foreign company, which is a constituent of the contractor, shall have to remove and export all its property subject to Article 27 and the provisions hereof, provided that in the event the ownership of any property is in doubt or disputed, such property shall not be exported unless and until the doubt or dispute has been settled in favor of the foreign company. Now, my lords, kindly to 79. This is very, very important, my lords. This will, my lords, this will allay the fears of my Lord Justice Bagchi on the interpretation, my lords. I just invite my lord's attention to page 79, paragraph 33.4, which is 33.4 in the production sharing contract also. It's identical, comma, full stop, identical. What does it say? The arbitral tribunal shall consist of 3 arbitrators. Each party to the dispute shall appoint 1 arbitrator. Now see, and the party or parties shall advise the other parties. The 2 arbitrators appointed by the party shall appoint the 3rd arbitrator. Now let us take 2 scenarios. Government appoints an arbitrator. Right, Maras? Who are the party or parties? Party or parties? If it is the parties who appoint an arbitrator, then it is party. Government will appoint one. If it's government appoints an arbitrator, the parties will appoint one. I hope I made myself clear. This clarifies in the next 33.5. Therefore, there's no question of the parties being one party because that's defined itself. 333.5. Any party may, after appointing an arbitrator, request the other party. Why bracket parties? Because the parties may appoint an arbitrator. Then it will only be a party. If a party appoints, that means that the government appoints, there will be parties. Which is why IES, it put in brackets. In writing to appoint the second arbitrator. So the parties will appoint the second arbitrator. But if the parties appoint an arbitrator, the party will appoint a second arbitrator. So inherent in the definition itself of appointing an arbitrator is the contemplation that the parties will appoint an arbitrator. The operator cannot. This is from the model PSC in the production sharing agreement. It is replicated word for word, comma by comma, full stop by full stop.
And in every PSC,
this is a clause in every PSC with us. Now, then this is the other important thing. And then, if such other party fails to appoint an arbitrator, such other party, within 30 days of the receipt of the written request to do so, such arbitrator may, at the request of the first party, be appointed by the Chief Justice of India or by such person authorized by him within 30 days of the date of the receipt of such request from amongst persons who are not nationals of the country of any of the parties to the arbitration agreement. So the assumption is, Mullahs, that under Section 11, it's the Chief Justice shall appoint, which means, Mullahs, an international commercial arbitration. So every term of the contract, every term of the model contract contemplates a foreign entity, Mullahs, participating in the process of winning any mineral, Mullahs, consistent with our law. So it's quite clear, Mullahs, that if this is correct, Mullahs, then the next question doesn't arise. If our interpretation is correct, then the next question will arise, subject to what my Lord said, there is a big fraud. Because fraud unravels everything.
I was only talking about that matter, Delhi Metro.
Oh, that of course, that of course.
No, we were only pointing out that why the argument was that in a curative petition we interfered.
Yes, of course.
We interfered in that case because
The
a
allegation.
case of committing fraud was made out.
I agree.
Because in curative normally you will be very
That's
reluctant.
also had a lot of ramifications in the international community. I might just.
Pointing out, and rightly so, that in an exceptional case you will interfere in curative.
Yes, yeah.
And that's the right way of
Absolutely.
curative scope.
That's right.
But we interfered in that case because we found that it was a case where fraud was committed.
Yes, I know. I appreciate it. 3 honorable judges, it is not 5, Malas. 3 of your lords. 3. 3. 3, Malas.
3.
3, Malas. 3. 3.
Just
3. Yes, your lordships. That's all on Malas on this, on the model. Now, Malas, I will not read 33.4 and 33.5 because I've already interpreted in the production sharing contract. This is exactly in the same terms.
And essentials of the PSC.
The essentials of this model are incorporated there. Now, Malas, I want to make a different argument. I'm not repeating what Dr. Singhvi said. I wanted. That's all right. 2(1)(f). Malas, as sorry.
It's very compilation, Mr.
No. Just the statute. Yes, 2(1)(f).
Page 6.
Page 6. Yeah, I got it. Don't worry. If I may, Malas, read, my Lord Justice Bakshi, may I have your Lordship's attention on 2(1)(f). International commercial arbitration means an arbitration relating to disputes arising out of legal relationships. The next is important, whether contractual or not. Considered as commercial under the laws in force in India. So you may have a contractual relationship or you have a non-contractual relationship considered commercial under the laws of India. So forget parties for the moment. There's no doubt, Mullah, there's a commercial relationship between NICO, BP, and Mullah's with the union. No doubt about it, Mullah. Government of India. So that part is established. Nobody can doubt that. Forget about the party definition. I'm not on that. Now come to B2. And where at least one of the parties is a body corporate which is incorporated in any other country, in a country other than India. That's a fact. That's not a matter of interpretation. So two things are established here by the definition itself. There is a commercial relationship according to us under the contract. If you start interpreting party and parties in that context, it doesn't matter because there is a commercial relationship covered by the definition. And the second necessary ingredient is I must be a body corporate incorporated in a foreign company. That's a question of fact that nobody can dispute. So how can you say it's not an international?
It's not in dispute at all.
So how do you say it's not an international commercial arbitration? Forget definitions. On its own terms. Once I'm covered that there's a commercial relationship, we say it's contractual and it's clear. But even if it were not contractual, it's a commercial relationship where I get 10%, he gets Muller's 30%, and Reliance gets 60%, or whatever is extracted. And the terms and conditions that are binding on me obligate me to deal with it in a certain manner as set out in the production sharing agreement, which is part of the Model Code of Conduct. So there can be no doubt from any stretch of imagination that this is a international commercial arbitration. party means a party to the agreement. That Dr. Singhvi has argued. Let's not repeat what my colleague has argued. So, that takes care of this part. And now, just see, sorry, how the impugned order deals with it. Page 39 of the first volume of Reliance. Whereas we are given, because I have a different brief, but we have correlated it with the Reliance brief because your lordships have been marking it there.
Paragraph 7.
Para 71, at page 39. Let us begin by analyzing the first of the material issues, whether the arbitration proceedings inter se the Union of India and RIL was an international commercial arbitration or not. For this, it would be prudent on our part to commence by tracing back our steps to the observations made by the learned arbitration tribunal in the award, which are reproduced below. There is no dispute that the claimant is required under the contract to lead the contractor party under the PSC. Its interest and those of BP and NICO were aligned vis-a-vis the respondent, and they had consistently so acted. However, not being a party to the arbitration, should the costs incurred by each of them be included as those incurred by the claimant and recoverable from the respondent. In the tribunal's view, this should not be. The scheme of the PSC is such that the claimant, as operator, is the only party in the PSC entitled to deal with the respondent. Neither BP nor NICO had sought to join the arbitration as a party. The respondent had throughout these proceedings maintained that BP and NICO had no right to be heard substantively, although the tribunal had on occasions permitted them to make certain statements. Whatever the costs incurred by BP and NICO, if not recoverable as a party, could not be permitted to be recovered through the conduct of the claimant. That was not what was contemplated in the PSC, and the tribunal should not permit it. Interestingly, it is based thereon that the learned tribunal further in its award held, we fully accept and recognize that the named claimant in this arbitration is IRL, and that NICO is not formally a party to this arbitration. How does this lead to any conclusion whether there is not an international commercial arbitration? As I have explained to your lordship, I am forced to appoint an operator. I have to choose. I can appoint a foreign entity. I can appoint a domestic entity. If the logic is right, the foreign entity becomes the operator, then I'm international commercial. If a domestic entity becomes, I'm not an international commercial. How has the arbitration got to do anything with the definition? And I don't know the consequences. Can kindly see a foreign party. I don't know the consequences of this. If I appoint Reliance, I'll be told by a court later that, look, cost will not be awarded to you because he's carrying on the arbitration, and therefore you are not an international, it's not an international commercial. How could any foreign entity ever know that?
There is no remedy available.
There is no remedy available for me, unless it is provided that if you appoint a domestic entity, then only that will be challenged, Mullah, that will be contrary to 2. Even that would be bad. Ignoring the aforesaid while adjudicating upon the issue where the arbitration proceedings inter se, the UI and Union RIL being an international commercial arbitration, what was held by the Supreme Court in RIL, the learned single judge went on to observe, in the opinion of this court, disputes that were subject matter of arbitration in the present case also relate back to the main contractual rights of the parties. Under the PSC, it matters not whether this view was taken in an administrative order. We are not concerned, just Dr. Singhvi has argued this, Mullah. So I'm not going to repeat that, Mullah. That's already been argued. That's on the section 11 part, and Mullah, the finding of the decision of this court, Mullah, as a sitting singly, binding on parties, being a judicial proceeding, all that my learned friend has argued. So let me not, Mullah, traverse that at all. But this is the logic, Mullah, that the learned division bench applies for the purposes of rejecting the claim that this is an international commercial arbitration. Now, let's get into the meat of the matter. Now, as your lordship knows, and as was pointed out to your lordships, my lords. First of all, my lord, just a background. We are the block, there are 3 blocks, my lords. I can tell your lordships, as far as the Reliance block is concerned, the area is 7,645 square kilometers. That's the extent of the block. And your lordships will find that oil and gas are in the interstices of the deep sea. This is not something that happens in the continental shelf, my lords, which is 30 kilometers from the coastline. You find them in deep sea, my lords. Now, the block that was with ONGC was closer to the coast. Right, my lords? Block given to us by them was a little far away from the coast, but they were contiguous. Part of it was in the deep sea. Part of the first block also was in the deep sea, but mine was all in the deep sea. And wells are dug to find out where the oil is. You never know, my lords, what the output is. How much volume will there be of gas, of oil? Nobody knows, my lords. It's only when you dig a well, you dig another well, you dig a third well, you get to see the expanse. And then, of course, on the other side, ONGC is also digging wells. They'll get to see the expanse, right? All this information goes to the Director General of Hydrocarbons. This is very important, my lords. I have no relationship with ONGC because they're an independent contractor. They will not share their data with me. I will not share this data with them. I will never know whether there is a connectivity or continuity, whether there's a reservoir or not. It's when all the data is collected, you figure out with seismic data and with other data. And because when you develop a site, my lords, let me just, so that your lordship knows the technicality of it. When I develop a site, my lords, or dig into a well, I have to give a development plan. Why I want to dig into this well? That goes to the Director General of Hydrocarbons. He will clear it. And as I start digging and I start getting data, I will simultaneously, my lords, give that data, forward that data to the Director General of Hydrocarbons. So he knows exactly the progress of the development, right? And each well, my lords, and the data each well has to be forwarded to the Director General of Hydrocarbons, just as the data ONGC is forwarded to the Director General of Hydrocarbons. As it happened, my lords, ONGC didn't do anything. This is very important for your lordships to know. ONGC did not do anything. They were only surveying. And my lordships should also know, they have actually surveyed this entire area much before the contract of 2000, of April 2000. Actually, they were surveying this area even in the 80s and the 90s. So they had a broad idea. And when I show to your lordships, my lords, the pictorial interpretation of where the blocks are, and we're going to upload it on your lordship's computer, your lordship will realize what the nature of the block is, where it was dug, where we found A1 and B1, where we actually found initially that there is oil. Then we start digging others, and all this data is given. And the reason why I'm telling your lordships this is very important. The reason is that when ONGC filed a petition, this is the first time I've seen ONGC blaming the government of India. You will find in the petition, ONGC saying, you people had the data. All that data supplied by me, all the data supplied by Reliance was with you. You would have known from the data that there is a reservoir. You are at fault. This is part of the petition of ONGC, and the government of India replies, and the Director General of Hydrocarbon replies, what are you saying? ONGC, you did nothing. You never developed any well. You are the ones who have put us into this trouble. That's all on affidavit. And the data supplied right from October 2002, because your lordships had the impression that we suppressed something. I will demonstrate. The data supplied from October 2002, January 2003, 2004, 2005, 2006 shows that there is a reservoir. Data of ONGC in 2007 itself shows that there is a reservoir. But they did nothing about it. And they blamed us then, that we suppressed a report of 2003. When all of the reports which show much more than 2003 were both with the government and with the ONGC. His own witness accepts that fact. Maharaj, the international commercial arbitrations are not conducted in this fashion. It took 18 months, Maharaj. They looked at every piece of data, every slide, every survey, and then came to the conclusion. They said, I should have forwarded this. It is a breach, but it's not material because they had all this data. What the division bench picks without analyzing anything. In 4 hours, how many hours did it take? In 4 hours, this argument was over. It took 5 years before the single judge. 18 months before the international commercial arbitration. And you suddenly in 4 hours, you say, no. In 2003, you didn't. This is suppression. This is fraud. You have deprived the government of India. This is the background. Now I'll take you through the documents. Now kindly, let's first see the petition of the ONGC.
It was argued for about 9 days. Not 4 hours. That's not true.
Or maybe 6 hours. I don't know. I was told 4 hours. I may be wrong, but I can stand because my learned friend may have been there. He can inform us as to how many hours.
Both of us were together before the division bench. Therefore, he doesn't.
I was
person probably.
No, I may be wrong. I'm just what I was told.
You may have your own flourish.
This is in passing, nothing to quibble about. If it's 4 hours or 4 days, it doesn't matter.
It doesn't really.
It is the reason.
Yes. Now let's kindly see Reliance Volume 3, page 842.
Courts are liberal like us.
I know. But we follow also discipline of this court. The Lordship tells us this much time and we do it. At least I have always come.
We also keep on learning. Yeah. So many things, all of you.
These are new areas, Maharaj. This is, we all learn.
These are not the cases that we keep reading on day-to-day basis.
And also it has far-reaching implications, Maharaj. So the future of the country, forget about this case or that case, we are not concerned. I'm more concerned with the future, Maharaj. As I said, Maharaj, the other day, there are 3 things you require in this country. Finance, that is capital, technology, and human resource. We have human resource, but that human resource serves capital outside India and technology outside India. So we serve them. The IPR belongs to them. They exploit it in terms of goods and services. They earn the profit. We have human resource. Till we invest in technology and make this country economically prosperous, we'll never be able to compete with the rest of the world. And the way to do it, and I've always been saying this, sorry, Maharaj, I'm a bit beyond the topic. I've been saying, Maharaj, the United States spends $650 billion every year in R&D. China spends $540 billion every year in R&D. India spends $80 billion. That's the gap. Because that's how they produce IPR. And most of it is in the university system. Most of this goes to the university system where private capital collaborates with universities to create IPR. This is sad. Anyway. Let us kindly see 842. Which Reliance?
This is volume 2, part 3.
Volume 2, part 3. 852. Yes, kindly come to page 860. Just This is ONGC's writ petition. Yes. This is ONGC's writ petition. No, that's why I gave you also the background. My lords have the page.
Yes.
The present writ petition is being filed under extraordinary circumstances and raises very serious and vital questions of public law, public policy, and public interest. The present petition is necessitated in view of bona fide belief on the part of the petitioner based on the seismic data made available by respondent 3 very recently in 2013-14. 3 is Reliance, which suggests that while exploiting its own block and operating 4 wells for that purpose, respondent 3 has exploited not only natural gas within its block, but has exploited substantial natural gas from blocks in the control of the petitioner. In effect, the respondent 3 has, as is recently believed, taken out gas running into approximately 18 billion cubic meters, quantity between the years 2009 and 13, and continues to do so even till date. From the combined gas reserves of the petitioner and respondent 3, the present writ petition is being filed inasmuch as, by virtue of the provisions of the Act and the rules, the respondent 1 and 2 have been empowered to deal with precisely such a situation and to find solutions thereof to the satisfaction of all concerned in that direction, upon the petitioner having brought the matter to the attention of respondent 1, that is Government of India, during several meetings having taken place between September 13 to 14 for resolving the issue by appointing an independent agency in that regard. So their allegation was, we've been actually, and the data is provided by us, we've been actually extracting this oil. A lot of this came from the block that they had, and therefore we have benefited. This must be resolved, and we are seeking the intervention of the respondent number 1 to resolve it. Right? Now, let's kindly then see. However, just a couple of lines thereafter. However, this petition also raises serious issue about the failure of respondents 1 and 2. Just mark it. Who is respondents 1 and 2? Government of India and DG, Director General of Hydrocarbons. So now they are blaming the Government of India and the Director General of Hydrocarbons. I have never seen this, mothers, ever. All the ONGC, most of the ONGC people employed by the ONGC, those retired or otherwise, are on deputation with Director General of Hydrocarbons. But anyway, that's another matter. And saying respondent 1 and 2, particularly the then Director General of Hydrocarbon, in not having taken necessary precautionary measures to prevent this situation, resulting in loss of several thousands of crores of rupees to petitioner, and in not having followed the mechanism internationally accepted for joint development, for which has been expressly provided for in the production sharing contract signed between respondent 1 and respondent 3, and particularly Article 12 thereof. So they're now saying that you should have followed, appointed a unitization process for winning this mineral, and you have failed in your duty. Now, let's kindly come to 870. This is the fact stated by ONGC. Paragraph 4. The brief, my lord has that. This is page 870, paragraph 4. That the brief facts of the case of the petitioner leading to present petition are as under. That on 12/4/2000, block KG DWN 98.2/2, that is their block, which is a new exploration licensing policy, round 1 NEL, was awarded to Kane Engineering. Kane Engineering is another private company, an international company involved in exploration and production. The production sharing contract was signed between respondent 1 and SEAL, and this was the effective date as well on 12/4, That's the same date, Malas. SEAL was with 100% participative interest and operator in that in year 2000. So, Malas, this block 98.2/2 was given to SEAL, and they had a similar agreement. In 2003, petitioners submitted to the government for assignment of 90% of the participating interest and operatorship of the block from SEAL, for which the approval of the government was received in 2005. SEAL retained 10% participating interest. First PSC amendment was signed with effective date as 3/3/2005. The petitioner became operator of the block from this day. Just pause here, which means obviously from 2000 to 2005, they didn't do anything. No development. Was with SEAL. SEAL had the block. They gave up. Why did they give up? Well, it's obvious they didn't find much resource. No company gives up like that. Anyway, they had 90%. It doesn't matter. They said, okay, now you give it to us. Give us the participating interest to the extent of 90%. Now kindly see. 3, Roman small 3. The petitioner submitted a proposal to assign 10% of the participating interest to HOEI, Hydro, Oil and Energy, Norsk Hydro, later Statoil. That's another company, Norwegian company, right? And 15% to PIB, Petrobras, Brazilian company. So 10% went to a Norwegian company, 15% to a Brazilian company. To respondent, Petrobras to respondent 1 on 9/10/2007. So we are now in 2007. Sorry. Yes. And why did these foreign companies come with us? Because we had discovered some oil by that time. We had not started extracting, but we had discovered. And the Director General knew about it. We gave him all the data because we had dug the wells. We started production only in 2009. So that's why many foreign companies came. But they left. They didn't find it something that needs to be exploited. Maybe the commercial interest was not there. But that's speculation. I can't say anything about it. That's speculation only. That's all right, but it's still speculation. We can't give the reason to the court as to why they left. Normally, that's the case, but anyway. Yes. Let us kindly see at Roman 5 that it is pertinent to note that the block was under rig moratorium for 3 years from 2008 to 2010. So, Maharaj, when I start production, there is a rig moratorium. They have no data. They have nothing. They have no rig. And then he files a petition, there should be joint development. Isn't that which surprising? Then item small Roman 6, Maharaj, that PIB, BV and Statoil assigned their participating interest to the petitioner. So they also left. And assignment documents were submitted to respondent 2. The approval of the authority is still awaited. The SEAL assigned that seal assigned its 10% participating interest to the petitioner by letter dated 11/11/2011, and thus petitioner became 100%. So they 100% only in 2011. Everyone else left, they had done nothing about it. Explore. Leave it to me, I'll show that. Now, the approval for restructuring of timelines was received by the Director General, by Director General's letter of 22/6/2012. The product sharing agreement, effective date was made on 25/9/2000, and exploration period extended till 29/12/2013. Kindly see, exploration period extended to 2013. We had explored, we had found the oil, developed it, started producing it in 2009. And their exploration extended to 2013, and they are blaming us. That after exploration, into extension of the exploration period, the petitioner effectively having 100% PIN for submission of revised declaration of commerciality, and to optimize the cost of the integrated sectoral hydrocarbon development of the discovered reserves in the two blocks of the petitioner, detailed G and G, interpretation was carried out by petitioner. Therein it was observed, now see this, therein it was observed that the laterally aggregated channel features of G4 pools extends southeast into the adjacent block of respondent 3 and appear to have continuity with the producing pools in the aforesaid block. So when did they discover this? In 2013, after 2013. Then the true copy of the maps showing locations is such and such. Now, let's kindly come to Roman 9. No, let's read this. A true copy of the map showing locations of blocks of petitioner and respondent 3, map showing the reservoir continuity between the blocks of petitioner and respondent 3, and map showing 4 wells drilled by respondent 3 near the block of the petitioner is filed here with this marked.
These maps are there from 2007.
I will show that these maps are there right from 2007 onwards with ONGC. With ONGC. All that is available with them. That between 2000 and 2014, respondent 3 has first explored block so-and-so, awarded to it after taking necessary permission from respondent 2. It then would have submitted necessary exploration data as well as well data to respondent 2. What ONGC is saying is all this data has been given to you as required under the law and the product sharing protection. At stage, respondent 2 should have been vigilant. Should have been vigilant to realize that the exploration of respondent 3 and its blocks showing reserves was a sufficient indicator that there is likelihood of a common or continuous reservoir between respondent 3 and the blocks of the petitioner on account of seismic and geological features. So ONGC is telling Director General, you failed in your duty because all this data was available with you. Respondent 3 was sending this data to you. What were you doing? And then I am blamed, Mullahs. You don't do your job. You are an independent Mullahs contractor. The block is assigned to you. You have to develop it in terms of your obligations under this very production sharing contract. You don't do anything. When I recover something, I don't know to what extent anything has come here. I recover it in terms of the contract, and you say that I have cheated. I've already given this data to the Director General of Hydrocarbons. Anyway, that's right. They have both sides data. They have ONGC data and they have respondent 3 data. On account of seismic and geological features, it may be pointed out here that over millions of years, these sandstone deposits, rocks containing gas, would have been formed in such a manner that there would be continuity over a long distance, sometimes as much as tens of kilometers or more, wherein the reserves of natural gas would be trapped in such a manner that exploitation of at one end of one's block and would actually result in draining out gas from the reserve situated someone else's block.
So what is this? This is basically nature.
This is nature, Malaj. This is the way nature functions. We don't know how it functions. But Malaj, if your lordship looks at the spatial data, you will find stratas and stratas where gas can be trapped. Now the gap and channels, the gas can escape. It can escape through flow of water. It can escape through shales. So you may have a reservoir. In other words, you may have continuity, but you may not have any connectivity. So even if there's a reservoir, it doesn't show that there is connectivity. Now kindly come to page 870. Yes, I've already said that. 876, small Roman 10.
Page 874.
Yes, sorry.
Internal page 23.
I see.
The target appears to be there are motive attributed to the then Director General. The ONGC
Yes.
is attributing serious motive
Yes.
to the then Director General in the government of India.
Yes, yes.
Some individual officer is being blamed for all these things. That's why page 874 is slightly interesting.
This is understood. That's the paragraph. This is understood in petroleum sector internationally as draining of one license from another block under rule of capture. Well, the rule of capture, I'm sorry to say, doesn't apply because in the United States of America, these are private parties that are given, and wherever they find it's like water. So the regime in the United States is different. So we don't apply the rule of capture. The production sharing agreement doesn't apply the rule of capture. So this is a misnomer, mothers. This ownership is the government of India. Question of rule of capture doesn't arise. So this really is incorrect. As a matter of law, it's incorrect. Mothers, I delve into the subject, mothers. This is what the state of affairs is. Despite this, and your lordship is reading the bottom. Despite the submission of the development plan, respondent 2 seemed to have neither objected to the modus operandi adopted by respondent 3, nor even forewarned petitioner at any stage. That's the motive, mother, that is attributed to respondent. But you will see what respondent 2 says in response.
Motive is they are saying that Director General, according to them,
yes,
Director General deliberately closed eyes, and you then in the above paragraph, what they are saying, respondent 3
yes,
drilled the 4 wells.
Blocks from the blocks of the petitioner, and wells have been so drilled and constructed that there is a pre-plan. No. This is it is Director General's mistake, mothers, not mine. It is attributing. You will see what the Director General says in response.
They are not using the innocent word of mistake. They are using word of motive.
No, correct. I'm saying something else to your lordship. Mothers, that fact would be right, may be right or may be wrong. I'm just mentioning to your lordship. Will you just allow me? The Director General of Hydrocarbons responds by saying, see your conduct. You knew this yourself. Mothers, let's be clear on it. Both ONGC and the Director General of Hydrocarbons knew of this continuity through data that I will place before your lordships. So for the ONGC to blame the government of India is saying, that, look, I am not responsible for all this. And Director General of Hydrocarbons tells ONGC, but you knew about it. Your own data shows that. So what were you doing? Why didn't you not develop? And now you are telling us in 2013, apply unitization. How can it be done? There can be no unitization at this stage. This is how it panned out, Mullahs. And Mullahs, kindly, let's be clear on one thing, Mullahs. There is no stipulation in the contract on migration of gas. There is none. What does the contract say? Whatever gas I find in my block, I can extract it. There is no illegality. There is no illegality. I can understand a clause in a contract which says in the event of migration, you stop. If you get to know, just stop. Right? So if I am at the cusp of actually producing, and there is a clause in the contract says if there is migration, stop. How will you get to know what the extent of the migration is? You never know. You will only know, Malas, and I tried to figure out from the experts, Malas, you only know if you dig a well in your area, right? And then you put what is called, what is that called? The thing that you call, you put in the block and then it comes on the other side.
Size channels. Full fold. Channels inside.
Good.
It's the full fold.
No, when you put something in one well, it comes out on the other side.
Tracers.
Tracers. Concept called tracers. In other words, when you dig it from one side, you put a tracer on that side, it will emerge on the other side, and then you can calculate the extent of the migration. Otherwise, you don't know. Because, as your lordship knows, Maharaj,
It's like a dye put in a water.
Yes.
Or a cashier stuff.
Exactly.
If the dye is carried, it will have the.
Exactly. If you will know, Maharaj, right? And then you will know the extent. Now, you don't dig a well, you don't do anything. You can't, and then you say there must be migration. Well, any expert in the field of oil and gas will know that in a contiguous block, there can be migration. Any expert would know that. Provided there's a reservoir, there is continuity. So the first thing to do is to go to your own block, dig the wells, find out what the data is. All this sent to the Director General of Hydrocarbons. I get my data sent to them. They get to know there's a possibility of a reservoir. Then they say, okay, stop. Now let's see if there is any connectivity. Well, continuity may be there, but connectivity doesn't establish connectivity. A flow of water will take away the gas. If I say $10 trillion, well, as I just give you an example, GSPC, there was an announcement made just 5-7 years ago that there are 20 trillion cubic feet of gas. What has been found? 0.01. Today, I'm telling your lordships, today, 0.01. Where is it gone? 10 trillion we had predicted. What did we get? 2.32. 1.2 trillion they predicted. ONGC, Maharaj, a trillion. And what did they get? 0.377 billion. A trillion. Where is that gas gone? Do they know? Do I know? How do you calculate volumes? It's gone, wherever it's gone. What is extracted is extracted. And how do I know what I've extracted is theirs and what is mine? Or theirs or mine that concept doesn't exist as a matter of law and as a matter of contract. This is a complete misappreciation of the very concept of how you win a mineral. Then come to.
The next line is very important. They know, had the respondent number 2 been.
Yes. Can we see what he says, Manas? Please, paragraph, this 874, last paragraph, despite the submission. Despite the submission of the development plans, respondent 2 seem to have neither objected to the modus operandi adopted by respondent 3, nor even forewarned petitioner at any stage. Had respondent number 2 been vigilant, respondent number 3 could not have taken commercial exploitation even within its own block in view of this nature of the deposits and likelihood of misuse of gas reserves of petitioner by respondent 3. Clearly, as per Article 12 of the PSC, a joint development ought to have been suggested by respondent 2 to respondent 3, which would have resulted in a common development of the said reserves by respondent 3 and petitioner. I started production in 2009, Manas. He was in rig moratorium till 2013. What is he talking about?
How do you do these stages, exploration, development, and then production? These are the initial stage.
This also proves that there is no motive and malice.
No, that's true. That's true. So, Malas, that's where this is. Kindly now come to now the prayers. 889. 889. Yes. Now, let's just kindly see the scenario. He says now we are, this petition is in 2013? 14? So, by 2013, I've extracted most of the gas. By 15, it was over. So he wants a joint development now. How will that happen? There can't be joint development, Mulas. Because for joint development, you have to dig your own wells. How much money does that take? $2 billion. What is the reserves that you find? Found, Mulas, 0.377 trillion. What is the value of 0.377 trillion? Less than 2 billion, 2 billion. So you lose. You lose money, and I will stop whatever extraction is left. I will stop that, and Government of India will lose. So ONGC will lose, and Government of India will lose. And you want joint development at this stage. Now see the prayer, Manoj. Issue a writ of mandamus or a writ in the nature of mandamus or any other appropriate writ, order, or direction, directing respondents 1 and 2 to forthwith appoint a truly independent agency to establish continuity. Mother, just pause here. To establish continuity. Mother's ONGC in 2014 is not even stating as a matter of fact that there is continuity. Forget about connectivity. Yes, independent to establish continuity of reservoirs across the two blocks and for gas balancing in accordance with the provisions of the Act. Rules and PSC signed between respondents 1 and 3 and further direct that the said independent agency shall function directly under the supervision and control of the Honorable Court. Mullahs, actually gas balancing is taking place even today, Mullahs, in the Hazira block, where whereas 2 foreign entities are involved and an Indian entity is involved. What happens in gas balancing? Let me just explain that to your lordships. What happens is that when 2 wells or 2 areas are equally sufficient reserves of gas or petroleum, right? And they are both operating simultaneously. What will happen is part of one will flow to the other and part of the other will flow to this side. So what they do is they have an arrangement of balancing. They will take a time frame within a certain period, how much has possibly flown from one side to the other and how much the other side has flown, and they will do a balancing and they will adjust the thing. So he wants balancing. Or what balancing will he get it today? At this point in time in 2014? B, Malas. Issue a mandamus or a writ in the nature of mandamus or any other appropriate writ, order, or direction directing respondents 1 and 2 to immediately take necessary estimation of volumes of gas for gas balancing from respondent 3 from the date it commenced actual commercial production till date, and for future production, and further direct respondents 1 and 2 to ensure that respondent 3 agrees to compensate the petitioner if the petitioner is found entitled to by the independent agency. This then was the prayer, Malaj, of the ONGC in the context of these allegations. Now, let's kindly see what the reply of the union. The reply of the union and the reply of the Director General of Hydrocarbons is almost the same. Some little variations, which I need not trouble your lordships with. 155, Volume 2, Part 4. Where do you do Screen, Malas. It's also on the screen of your lordships. Both are there.
Yes, we have got copy also.
Yes. Now, let's kindly see 1056, the preliminary objections.
Yes, 1056.
Yes. What happened was in the meantime, let me also be quite open and frank before your lordships. Nobody wants to fight with the government. Let's be clear. Big industry doesn't want to fight with the government. There are many, many projects. They always want to conciliate. Okay, get down, get across the table, let's finish it. Why do you want to go into all this? It's in that spirit we said, okay, have an independent agency, but it's without prejudice. We'll come to that. The writ petition of the petitioner has become infructuous pursuant to the appointment of an independent agency. It is submitted that petitioner is a public sector undertaking and has filed the present petition against the Government of India, alleging failure by respondents 1 and 2 in ensuring full and complete compliance with the provisions of the Oilfields Regulation and Development Act. Petitioner in the writ petition in its prayer has sought for a direction to respondents 1 and 2 for appointment of an independent agency to establish continuity of reservoirs across the block and for estimation of the volume of gas owned by the petitioner and block owned by the respondent 3. This is the G4 block 98/2 in contrast to the respondent 3's KG block 98/3. The writ petition in the present form is premature and is liable to be dismissed in limine. Petitioner never raised any issue. Note this. Never raised any issue of connectivity of reservoirs channels ever since the petitioner was granted a mining lease for Godavari PML block in 2008 and more so even in 2009 when the production started from the adjacent block. Well, they could never have raised because they did no work on their side. The petitioner woke up from slumber only in July 2013 when he requested the government to provide the GNG data, that too to analyze the continuity of the pool. Therefore, this honorable court should reject the petition on this ground alone, that the petitioner, who was never vigilant and mindful of his rights, cannot now turn around and make frivolous allegations against the Government of India. Now kindly see the preliminary submissions at last paragraph of page 1057. The Godavari G4 block was awarded to the petitioner on nomination basis in 1997 and later converted to production mining lease by approval of government by letter dated 18/10/2010. There were 3 discovery wells, G42, G43, G4/2, G4-3 and G4-4 in this block, which were in the near vicinity of block KG DWN 98/3, which is being operated by RIL. 98/3 is mine, the others are in their block. Now, the petroleum exploration license for block KG 98/2, which is their block, was awarded effective 2000 with 100% participating interest of CAN. 6 wells were drilled between February 2001 and December 2001, and 3 discoveries were reported by SEAL. SEAL offered 90% participating interest to the petitioner in November 2003. Petitioner required 90% participation interest with operatorship of the block since March 2005, drilled another 13 wells till 2010. Out of these wells, 5 discoveries were reported and other appraiser wells were drilled up to November 2010. This is all exploration, Malas. Declaration of commerciality for northern and southern part of the block was submitted to DGH on 21/12/2009 and 17/7/2010 respectively. I will demonstrate to your lordships that the 2009 discovery shows the reservoir in 2007. shows the reservoir. After preliminary review, the DOCs were withdrawn because the petitioner wanted to drill 6 more committed wells for complete appraisal of the area on the northern side, and said that the southern side of the block could not be developed by them due to lack of technology in ultra-deep waters. Thereafter, the remaining 10% participating interest of Cairn was also acquired by the petitioner, as such petitioner held 100% participating interest in the said block. Petitioner requested Government of India for extension of time to drill additional wells, which was granted by... Sorry. Where is it? Which was granted by Government of India, while letter dated 14/6/2012. However, still petitioner did not develop the block. The respondent 3 was awarded block 19-3 on April 12, 2000, made 19 discoveries in the block. The D1, D3 discoveries, which were adjacent to the petitioner PEL area, were notified on October 2002. Initial development plan was approved in November 2004. Addendum to this was approved in 2006, and commercial production gas commenced in 2009.
All these showed connectivity.
All these showed connectivity.
And given to DGH.
And given to DGH. All this showed, mothers. Continuity, yes. All this showed continuity. This is what we are concerned with.
Not connect.
I'm sorry?
Continue.
Yes. All these showed continuity. Of course, mothers. But that's right, absolutely right. So all that was there with them, mothers. Then, on the other hand, so if you show continuity, there's a possibility of migration. That's what has to be discovered.
That is the question.
That's correct, mothers. That is certainly the question. That's right. And they say there that there is possibility of connectivity. I'm not saying, mothers, the same what was said in 2003. The same is said there. In all these reports, mothers, let's be clear on this. And they, in fact, their own witness comes and says, if you read these reports, you know there's a possibility of connectivity. Not just continuity, mothers. So let's be clear. I'll show that all to your lordships. It's all there on record. And I'm their own witness, not mine. And all this has been dealt with, mothers. We're not going to reappreciate evidence here. All this is dealt with already in great detail, looking at all these facts. And what does the division bench do? They don't refer to any of this. Has you seen in the division bench judgment any reference to any of these things? This can't be. Well, you can't make people invest in the country and then say, look, you have stolen or you have committed theft, or what kind of message do you give to people outside the country? From the then, on the other hand, it is submitted that block KG DWN 98/2 was awarded to the petitioner on 11/4. Exploration period comprising of 3 phases of the work program up to 11/4/2008. However, the petitioner got extension of 3 years to 2011 due to rig holiday by Government of India. Simultaneously, petitioner was also granted appraisal period for of 3 years, 2007 to 10, from the date of the last discovery. Thereafter, the Government of India granted further extension up to 2013, by letter dated that for further appraisal drilling. From the above facts, it is clear that the petitioner had been granted all the possible extensions by Government of India under the PSC to facilitate the exploitation of natural resources in the interest of the country. Despite having availed all these extensions, petitioner has not been able to efficiently utilize the time and resources for early monetizing the field. It is pertinent to mention that in 2006, the petitioner proposed for cluster development. Whereas they then proposed for cluster development of the discoveries in its blocks G4, KG 98/2, since the discoveries in block 98/2 were of marginal in nature. And the same is evident from the minutes of the meeting of 18/6/2000. So, Maharaj, what was discovered was marginal in nature, which is why Keynes left. Statoil left, Petrograph left. Well, there was no substantial amount there. Why would anybody spend $2 billion for excavate something where ultimately you'll end up losing? Cluster means only just a few wells, Malas, in grouping together, that's all. Then, Malas, further the petitioner submitted DOC for the block, such and such in 2009, wherein the petitioner reiterated for the cluster development of its blocks. However, till date, the petitioner has not taken any step in this regard, though there was plans of cluster development of Godavari PML and KG 98/2 way back in 2006, no proper efforts were initiated for infrastructure development and production facilities, which shows inefficiency on the part of the petitioner. Since ONGC delayed, I was efficient, I extracted from my block, and therefore, Mullahs, now I am liable because there's a possibility of migration. Then, Mullahs, kindly see page 1062, paragraph 15. Can we show those? Video. No. Para 15, page 1062. The actions of the government. I'm sorry, Mullahs. My lord has it? Yes. The actions, my lord Justice Bakshi says that. The actions of the government clearly established beyond any doubt that there was no laxity on its part in resolving the issues. Allegations made by the petitioner are contrary to the facts of the case as stated by the petitioners themselves in their writ petition.
Mr. Subbal, the government of India, whatever way they want to, but their entire defense is that it came to their notice in July 2013, and after it came to notice, then they immediately, there were no laxity on their part. First of all, they made a reconciliation and mediation between the parties, so that matter could be amicably resolved.
Yes.
But
no, Maharaj, no, that's not the case. Not that they came to know in 2013. I will demonstrate to your lordships.
Their case we are talking, that you will pay 100.
No, their case, Maharaj, has both been rejected by the tribunal on the ground that they had all this data much prior to, in fact, from 2002 onwards.
We are not saying on
yes,
that.
Yes.
We are only pointing out what they pleaded.
So 2005, Maharaj, it will come later. It's 2005. I'll just show that to your lordship. Kindly see page para 27, 1066. This is very surprising, Maharaj. Even as per admission, your lordship see that? Page 20, para 1066, para 27. Even as per admission made by para 4 of the petition, the petitioner was aware of the extensions of their reservoirs on the basis of their own data of 2004-5. And DGH in his affidavit says exactly the same thing. ONGC knew, Director General of Hydrocarbons knew. So you can't say they got to know in 2013.
22.
Kindly see page 22, Maharaj. It's all para 22 at page 1064. It's all explained, Maharaj. So connectivity was known, Maharaj, continuity was known, possible connectivity was known. It is pertinent to note that petitioner's own claim is that the present petition is based on the seismic data made available by respondent 3 recently in 2013-14. It is further submitted that the petitioner was operating IGPEL since 97 and discovered G4 field and made gas discoveries in well number G4-2 in February 2004, in well number G4-3 in January 2005, and in well number G44 in July 2005. The G4 field is adjoining block KG 98/2 and KG 98/3, which is ours. Next line. It is also relevant to note that there was inordinate delay on the part of the petitioner in developing the field. So they got the data, they knew the data, they knew of the continuity, they knew of the possible connectivity, they did nothing about it. The government didn't do anything about it. I mean, the Director General of Hydrocarbons, ONGC did nothing about it. And well, if they did nothing about it, then in 2014, he says, no, you have a balancing agreement, you have a joint development. Then see, the petitioner never claimed for geographical area extending to adjacent block 98.3 while applying for PML in 2008. Now, why, normally I would not go into these facts, but because the division bench has relied upon a 2003 report given to the Canadian security authorities, which also talks of possibility of connectivity, right? Without any reference to 98.2, because no explanation had been done, Mulad. So this was on the basis of seismic data, which is maybe right, maybe wrong. But they knew thereafter that there was both continuity and connectivity from their own digging of wells, which has been appreciated by the tribunal and this whole claim rejected and accepted by the single judge, but denied by the division bench on the ground of the 2003 report without reference to any of this, which I have placed before your lordships. If you want to set aside a fact, then you have to discuss everything, no? You can't come to a finding of fact by disregarding all the data that's available with you as a court.
It was only established in 2015 finally. So all of this is not possible.
Yes. But as I tell your lordships, how connectivity was established now. Possibility of connectivity was there throughout, but how it was established. Well, what happened was then they wanted to find out how do we establish absolutely that there was connectivity. They dug a well in 2015. They dug a well in the ONGC block, their own block. They had already dug a well in 2004. They re-entered those wells and then checked the pressure. Then checked the pressure. They realized that there was a fall in pressure. And because there was a fall in pressure, there must have been migration. That's how they established that in 2015. Then all this became an issue. Oh, sorry. Para 24. It is pertinent, sorry, page 1065. It is pertinent to note that the issue of connectivity of reservoirs channels were never raised by the petitioner even in 2009. And I've already read this. When the gas production from D1, D3 gas fields 98/3 has started, even though the petitioner had prior knowledge of such production. Then next, this is important. I'll read the whole thing. In further reiterated, the respondent who has undertaken all efforts to resolve this matter amicably. Accordingly, this ministry wrote to petitioner and DGH for immediate and amicable settlement of the issue. The allegations of the petitioner pertaining to non-adherence to Article 12 for block KG 19/3 are misleading. It is submitted that Article 12 of PSC provides that the government may require the preparation of a joint development plan. It is pertinent to mention that the concept of unit development is defined in 12 of the PSC is applicable for discoveries. This is very important. Discoveries made in adjacent blocks for a better techno-commercial exploitation of available hydrocarbons. Article 12 of PSC is not applicable when discoveries are developed at different points of time and the development work has already been started by a contractor of one block and the other block has not become ripe for development. Hence, the question of government interfering in the instance case does not arise. However, till date, the petitioner has never approached respondent one in this regard. So what they are saying is, this whole question of joint development or unitization will only happen if you are at the same level of development. Then balancing can take place, then unitization can take place, all that can happen. But if somebody has developed, you have not done your duty. That's why I initially started on the proposition that under NEL, nobody is given preferential treatment. We are on an equal footing. So if you do not develop your well, you can't blame me. You don't develop, you don't do any work. Migration is a possible thing, it can happen. And if it does happen, and I extract it, then how are you blaming me for it? And all the data for every development that I make, a digging of every well is given to Director General Hydrocarbons. So they know, they have both sides of the data. Anyway. Then 26, 27. 27 rather. We just read, Madhaj. Now, 26, it is submitted that the petitioner for the first time raised this issue by letter dated 22/7/13 after being awarded the contract in 2000. As stated above, government has undertaken all necessary steps after the issue was brought to its notice.
36.
Then 36 now, Madhaj.
You can come to 1069.
106.
Ground number A sums up everything.
All
There
right.
is no need to read them further.
All right. Okay, I'll read it.
Probably this is what you want to point out to us, probably.
Yes, yes. As mentioned above, Article 12 of the PSC, as alleged by the petitioner, does not levy a mandatory obligation on the government. The bona fide intention of respondent 1 and 2 is established beyond doubt from their efforts pursuant to bringing the issue to their notice in July 2013 to bring about an amicable settlement of disputes through various meetings dated so and so and exchange of correspondence. In reply to Ground B, well, that really is only part of it.
The point is that was applied at one day delay.
Well, let's kindly see 1070. Kindly Ground C. In reply to Ground C, it is submitted that the mandate of the government, including both respondents 1 and 2, is not to hinder or obstruct the development of a field by a contractor. So let's kindly see. I have done my duty. I have done it expeditiously. I have done it efficiently. And I have, Mullards, under my obligation, Mullards, done what I had to do in terms of production cost, petroleum, cost petroleum and profit petroleum, and paid royalty to the government. I've done all that. All that was extracted by me. I'm not taking away anything from anybody. So it says, not hinder or obstruct the development of a field by a contractor. The issue of continuity of the reservoirs of the two blocks is yet to be determined independently by the third party. So they are not even saying that there is continuity themselves, brothers. And I'm shocked and surprised because it is established through data given to them. Not just continuity, but the possibility of connectivity. Till such time as the fact is scientifically established, government cannot instruct, obstruct, or otherwise hinder the development of a field by a contractor, specifically when the wells were being drilled within the physical boundaries of the said contractor's block as per PSC. So they themselves are saying that I am doing it in terms of the PSC. How can I hinder that? And well, what will happen if they try to hinder? What will happen? Government will lose. I will lose. And government will lose much more, Malaj. With all that each contractor has earned, which we'll share in 10, 30, and is it 644 million? And whereas to develop the other block, which is 98/2 and kg other, is 2 billion. So everybody will lose.
So that we delayed. He knew, and you told me I would not have been affected. I would not have.
Well, so the reply is that he knew, ONGC knew, he delayed, and even if I knew, I wouldn't have done the connectivity. Because you're at the same level of development.
And
Yeah.
Article 12, it is a download.
I'll come to that. Now, Mullards, now this is what this is. Now just read article. I'm sorry. Article 12, Mullards. What's the intent behind Article 12, brothers? Page 195.
It will be Reliance Volume 1.
Reliance Volume 1.
Page 263.
Page 263, brothers. Reliance Volume 1, page 263.
Yes.
If a reservoir in a discovery area is situated partly within the contract area and partly in an area in India over which other parties have a contract to conduct petroleum operations, and both parts of the reservoir can be more efficiently developed together on a commercial basis. the government may, for securing the more effective recovery of petroleum from such reservoir by notice in writing to the contractor, require the contract. Just pause here. Let's analyze this for a minute. In other words, Mullahs, the discovery happens in one area, in one contract area, which is partly in the area where the party has discovered, and partly in the area where the other party has the right. Then, if the government feels that they can be both efficiently developed together on a commercial basis, one, efficiency of development, and on a commercial basis, both things. Now, both things will not apply. Because I have already, by the time this happened in 2014, 2015, the operations end. So it can neither be developed together, nor is it commercially, on a commercial basis. Well, what's the commerce that you have to, assuming, I had not, so assuming by some, what should I say, God sent message to me that no, this is the migrated, let's assume that. This is migrated and this is mine. Let's assume. How will it be developed? I can't recover it. I can't extract it. Who can extract it? Whoever extracts it will have to come to my block. Let's assume by some magical reason I send the migrate thing back. So you'll have to develop it from your own block. Which means for you have to spend money, you have to invest. You will see the economic viability, commercial viability of such a venture. You may say, I'll let it migrate. What's the point of my developing it when you have already extracting it, and we'll share it, as the contract says. I get my money, you get your money. So I don't see the logic behind all this exercise. This is a conundrum, Mullahs. It's a legal conundrum that I cannot understand. As to how Government of India could have operated under, could have directed under Article 12, could have had a balancing agreement or contract, or could have revisited this issue. There's no way you can do it. It's a natural phenomenon. I can't, Mullahs, as I said, nobody controls nature. Take water, Mullahs. Take the example of water, upstream and downstream. Mullahs, I pick up in a river a glass of water and I can drink it. It belongs to the Government of India. But you let it flow. You know that it is flowing. You're not damming the water. So if you let it flow, then, of course, this is not an apt example because gas but I'm just giving a small example, Mullah, that this is not, you cannot blame me for something that you've not been able to do yourself. Something that you have engineered not to do, something that you are not capable of doing, something that you could have won had you invested, something that you could have done 5-10 years ago. You don't do any of that. And then you say that Reliance, you have cheated us. In other words, I don't have to spend 2 billion, but I can get 2.81 billion by way of damages. So I save my expenditure and I get money. This is a very strange way of looking at contracts of this nature and inviting foreign investors to come into this country. Then, Mullahs, the government may, so it's not sure, for securing the more effective recovery of petroleum. That also will not apply under 12.
Obligation is on the government.
And the obligation is on the government, Mullahs, not on me, not on anybody else. Under Article 12.
PSC mandates me to extract
Okay, no, that's all.
PSC mandates me to
It's all right. No, we're done. Okay, Mullahs. So that takes care of it. Now I come to, Mullahs, the data. Start tomorrow, Mullahs, or Monday?
Yes, we can start
Monday. Whenever you, now, Mullahs, I'm not asking for any adjustment, whenever.
No, Monday onward, we will take up in any case 2 o'clock.
Very well.
So that you can also,
Yes, yes.
because entire week is miscellaneous.
Yes, no.
All of you will be busy.
No problem. I am now committed. Whenever your lordship says, I'll be here. I'm sorry about today, Mullahs. I just needed, I didn't have enough time to adjust matters. That's
We will also do some urgent miscellaneous matters which are piled up.
very well.
By the time 2 o'clock, you can also
Very
comfortably.
well. Because it's a new topic, so I'll start with showing you the slides and all that. It'll take a bit of time to set it up. Because I'll have to show you the slides and I'll start on Monday then, Malas, if you also don't mind.
So like,
Yeah.
that's only 10 minutes is only left.
I'm obliged.
And we could see the difficulty which Mr. Sibbal is facing as compared to Dr. Singhvi. His assistance was only from right hand side. You are on both left and right.
That's right, Malas. Yeah. I'm captured, Malas.
These two youngsters are not permitting you to even breathe.
I know that. But they are the heart and soul of this matter. Malas. They work so hard, you can't imagine. In fact, we are what we are because of them.
They must be very, very well prepared. That's why they think that.
They're exceptional. They're exceptional. They are exceptional.
Single sentence.
Yes. Deeply obliged.
Continue on Monday.
Yes.